Lord, may I have Lordship's kind leave to mention a matter? My Lord, leave to file it with a certified copy of the order.
No certified copy. What is the urgency?
The urgency is, my Lord, restoration of possession has been ordered within 7 days, my Lord. That is why I am filing it.
It's a PP appeal.
Yes, yes. Yes. Wait. Watch.
Yes. Upgradation, expeditious hearing upgradations, please hand over the slip. Only expeditious hearing. First, please hand over the slip, expeditious hearing.
My lord.
Expeditious.
My lord, shall I?
Please wait, sir. Please wait. Expeditious hearing upgradations from the monthly list, please. Hand over the slip.
For upgradation, lordship, upgradation.
Expeditious hearing only. Please wait. Please wait. Any other expeditious hearing matters, upgradation? Expeditious hearing. Yes, applications. Applications. Applications, please hand over the slip. Please wait, please wait. Applications, please hand over the slip. New motions, upgradation, please hand over the slip. Indicate the urgency. Please wait. Let them take the slips. Otherwise,
The urgency on the next date of hearing before the trial.
please indicate that in the slip.
What happened, an order passed by the consumer court, where it's been upheld by the NCT.
What upgradation? Please hand over the slip, mention the urgency.
August, Lordship, I mentioned earlier.
Please indicate that. Yes. Yes.
My matter was,
Please use the microphone.
my matter was listed on 20th of July, but thereafter
Yes.
your lordship was not sitting.
Please hand over the slip. Yes.
Lordship, this is a civil division against the arbitral one of the order, Your Lordship, rejecting my application for amendment and for
What do you
reducing.
want?
Lordship, the date is fixed for 11th
Upgradation.
to be listed and for on the top because the otherwise
Upgradations, please hand over the
Lord.
slip, indicate the urgency.
it's written.
Yes. Please indicate that. Yes.
My lord, may I be permitted to mention, this is, my lord, upgradation of
Upgradations, please hand over
my
the
lord,
slip.
contested application, my lord.
Contested no. Please,
My lord,
motions.
kindly, any date, my lord, kindly.
Sir, please see the number of
My lord,
upgradations for motions.
For more than 1 year, my lord, I am waiting. Last,
Wait, let me see. Let me take up the motions first. Then I will consider.
any date, my lord, kindly, my lord.
Sir, personally, I do not have any. You decide which day I will take up contested. Not only one matter. I can take up contested. I have no difficulty, but I will not allow mentioning for upgradation of motions.
My lord, I have a
Please
lord,
consider.
my lord, item number 113 and 114 of today's list, your lordship.
Yes.
My lord, urgent, your lordship, my application.
Please. Today's list, please.
My lord,
113, 114
yes,
plus.
your lordship, it's very urgent, your lordship. My lord, kindly. Identical matters, your lordship. Either one of the matters would be taken up, my lord, that would
Already you hand over the slip. Let me see.
Yes, yes, lordship.
Yes.
My lord, extension, my
Extension of interim order.
Extension of interim order. Please hand over the slip. Mention when it is expiring.
My lord, I am mentioning in the earlier, but my lord, the matter is pending before the Krishnagore district.
Upgradation.
Kindly
Upgradation,
fix
please
the-
hand over the slip.
Kindly, my lord, kindly please.
My lord,
Please hand over the slip. Indicate the urgency. Yes.
New motion upgrade. New motion upgrade.
Hard on merits. Listed before the adjustment and without hearing, say that go through the auditorium. New motion, not motion.
New motion.
It's never been heard on merits, and I have been paying through my nose.
It had to be mentioned at the Calcutta.
may I be permitted to mention one matter? My lord, for restoration of the civil revision application.
Please hand over the slip application.
এটা আমার একটু
Upgradation of motions.
আমি পিছনেই ছিলাম, পিছন থেকে
Hand over the slip upgradation.
My lord, may I be permitted to mention a matter for your lordship?
Upgradation, please hand over the slip.
Shivaratma Mata, your lordship will release. They have kindly release order.
It had to be mentioned at the end.
My lord,
To be mentioned at the end.
বলছি স্যার
Sir,
My lord, may I be permitted to mention a matter before your
One
lordship?
matter, it was for returnable motion, I mentioned before your lordship. This
Motion
returnable motion. This matter was heard.
for upgradation you want.
No, this is not in the list even, my lord. I
Be
mean,
included. Please wait. Please wait. Upgradation.
my lord, I am suffering, my lord, since there was no,
I told you to hand over. Now you are
my
coming.
lord, since there is no interim order, my lord, it is against order of disappeal, my lord.
Please wait. Let me finish this. Upgradation of motions. Yes. Yes. Inclusions, motions. Please hand over the slip.
Dada, inclusion. No interim order.
Inclusion.
They are, my lord, harvest or
Hand over the slip. Inclusions. Please hand over the slip. Motions only, not contested application.
sir,
Motions. Please hand over the slip.
Lord, I have mentioned 4 times, this is, but matter has not yet come. But there is a specific direction of
Motion.
upgradation of, not,
Upgradation. Please hand over the slip.
it is not coming.
next date is on the 7th. They have closed my evidence without listening to me, and they have put the matter for hearing.
Please hand.
স্যার বলছি পিটিশনার ইন পার্সন একটা ম্যাটার স্যার মান্থলি লিস্টে রিলিজের জন্য রাখা রয়েছে স্যার ওটা কাইন্ডলি তাহলে রিলিজ করে দিন মান্থলি লিস্টে রিলিজের জন্য রাখা রয়েছে
My lord, may I be
হ্যাঁ হ্যাঁ
Which item?
2226 with 2227 item number
226. Triple 26 with 227 ওটা কালকে 2 মেনশনে দিয়ে দিন।
May I be
Lordship,
permitted to mention
inclusion.
a matter for your lordship? My lord, in this matter, actually, we had challenged the
What do you want?
inclusion in the list because
Motion.
new motion.
Hand over the slip. I told you.
Madam.
Inclusions, please hand over the slip.
But under
For correction, my lord.
Corrections, hand over the slip to be mentioned.
Well, due to urgency, I mentioned 7th is the next date before the court below for police help. The decree is of 30 years old. It is being successfully resisted. But after dismissal of section 47, again one revisional application has been filed. It is being stalled. Any time before 7th, if your lordship kindly takes.
Mentioning for releasing of the matter.
This matter, my
Deep
lord, hearing before lordship. 16/26. At the time of hearing, my your lordship asked me to place the written statements.
It is appearing under what item?
It is not appearing because my your lordship assumed the matter.
but
Hand over
may
the
I, may I permit
Inclusion, contested application.
contestants, please wait.
sir,
Yes.
may I permitted to mention my when your lordship is not here, my lord, I mentioned the matter because the other coordinate considering the urgency take up the matter. Subsequently, it has been detected that my lord once upon a time has consulted with the client. Therefore, his lordship did not ask the matter to appear in the list, but said that personal ground your lordship will not take. Now, my lord, thereafter, my lord, your lordship's officer is saying that once it is gone to that court, they will not accept. My next date is on Friday, my lord. Can it be, my lord? Because my lord, it is not my fault, my lord. But I mentioned, my lord,
Just gone down in the department.
No, no,
from-
Yes.
Yes.
না ফাইল ওখানে রাখা আছে 7 নম্বর করে ফাইলটা ওখানে আমারটা রাখা আছে
ওটা রাখা।
To mention contempt application, my lord,
Content, please hand over the slip.
the land was acquired in the year
mention for releasing
1970
the matter.
in spite of passing my lord's order, my lord.
Yes.
I'm mentioning for releasing the matter.
Yes.
Lordship,
New motion. Item number 192.
Upgradation. Please hand it. Yes, call the list.
Sir, you have to directly monthly it will become infructuous. If it is in the monthly list, it will become infructuous. Because what happened, my suit for eviction,
Lordship,
suit was at the argument stage. At that juncture, my lord, they filed a counter claim by amendment that has been allowed without assigning any reason. But challenging that although there is an order passed by a lordship should be disposed of within 6 months. Now, my lord, I am suffering, my lord, but if it,
Let me see.
Lordship,
Yes.
kindly allow
It
me
is
to
monthly.
Lordship, kindly allow me to mention, this is for inclusion and the matter was fixed.
Motion.
This one matter was fixed for contested application.
Contested, please wait,
a
madam.
monthly
Yes, call the list.
a monthly list, it will be my because in the argument stage.
But I will consider the slips then. Please wait. Yes, call the list.
My lord, only for extension of
Motion, my lord.
Lordship may kindly seize the order.
The computer new motion, not old matter never been hard.
I will consider that. Let me
Order is
consider
of
this.
31st, my lord, kindly seize the order first,
Yes.
which I am seeking for extension.
Appear করছি বলছে তো
Lordship is
yes.
having the file.
Extension.
Extension.
Lordship, I am
Yes.
the respondent number 5.
Yes.
My lord, this matter was mentioned and taken up by the learned coordinate bench, my lord, on the ground of urgency.
Yes.
My lord, in view of the subject matter and the urgency involved, my lord, even corporation has urgency, my lord, because there's a proceeding pending and there's an order of the coordinate bench to take steps. The entire building is illegal, no sanction plan, my lord. The sanction,
Saying
the
so.
municipality was, my lord, had gone to demolish it on 31st, my lord, but in view of the limited stay granted by the learned coordinate bench, my lord, this matter is appearing before your lordship, and the order is also expiring today, my lord. Well, I understand, my lord, the business of your lordship, my lord, is, my lord, list is very heavy, my lord. There is some urgency on our part also, my lord. So, lordship,
Kindly
kindly
fix
What is
take
the
up-
order? What is the order under challenge?
Well, kindly comes to page 3,
Page-
paragraph 10 of the order passed by the Honorable Justice Om Narayan Rai.
So please show me the impugned order, Mr. Laidi.
Yes.
That is
my
the
lord.
impugned order which is under challenge.
Impugned order, my lord, kindly comes to the order passed by the, my lord, commissioner.
Yes.
Lordship wants to see the order passed by the
Kindly-
commissioner or
It's under
the
challenge in this civil
Acha,
division
tribunal,
application.
tribunal. My lord, the certified copy we had moved without the certified copy. Certified copy. Certified copy. May I just place, my lord, the findings of the, well, first, my lord, the section 5 application has been allowed. Kindly comes to
30th of July 2026.
yes. Kindly comes to page 3. Now, what is the
You have not-
urgency?
You have not filed the certified copy
No,
earlier.
that this is the certified copy. This is my handed over. There was a leave granted, my lord. Point is that they are facing
Please
an
give me
order.
a minute.
Yes.
Please.
Kindly comes to page 3. Or this is internal page কত এটা? 7. Internal page 7. At this stage. It is a serious dispute with regard to demarcation. In 30 and 131 age observation without her. Yes.
Where is the sanction plan, Mr. Ladi?
Kindly comes to
So do you have the sanction plan?
yes.
Show me that sanction plan.
I mean, in respect of all the Malad matters, in 2015 Malad, there was a handover from Rajarhat municipality to Malad Salt Lake, Bidhannagar municipality. They are on affidavit saying that we have not been given the records. And in respect of all these plans, they are taking the stand that this is not available in our record. Therefore, ingenuine. Kindly see the division bench order where this has been recorded.
No, Mr. Ladi, till which date this plan is valid?
2016. And 2016, I have completed the construction. The inspection report as of today has not been given to me. And the demarcation is
You have
totally...
not got the inspection report?
No, nothing. They don't understand principles of natural justice. There has been inspection even after the last date of hearing.
Yes. Have you served the copy of the inspection
My
report?
lord, everything has been given, my lord.
Everything has been
Show me
given.
that
Show.
inspection
Show.
report.
Carrying
Show it.
inspection report, my lord.
Let us see.
Do you have a copy of the inspection
No, no.
report? Please
I
show
don't.
me that inspection report was served upon them.
My lord, they participated, my lord, and they are relying
No,
on that.
sir, only my question to you is inspection report, did you serve a copy upon
But
them?
I don't have the receipt copy right now, my lord.
Tomorrow I am
my lord.
keeping, please produce, show that the inspection
I-
report has been
Yes,
served upon them
I'll take.
prior
I'll
to
take
the
this back.
proceedings.
Very well.
On 3 days hearing was done on the even inspection report made even in after the last date of hearing has been considered by the commissioner. Kindly see the commissioner's report once.
Only one thing, my lord, only one.
Last date of hearing.
We have gone through the plan and our categorical stand is that this is
Sir,
not genuine.
maybe
No,
you have,
my lord,
you
they-
have inspected a
Yes,
property.
yes. I'm
Are
not
they not entitled to a copy of the
No,
plan?
They are. My lord, they may also disclose, my lord, since my lord, because when a plan is sanctioned, they have to pay the sanction fees. Let them also disclose to whom they have paid the sanction. fees.
2014,
That's
16.
one thing. You are,
They don't have in their
sir,
records,
you
so
are
therefore we
relying
have to do
on
everything.
an inspection report. So you are relying, so you have relied upon a document in the hearing. So please show me that they were served with a copy of that. Otherwise, there is a violation
I'll
of the
ask for the records, my lord.
tomorrow,
My lord, day after tomorrow, my lord.
day after tomorrow. On a query of the court. And this copy of the judgment. Mr. Mukherjee,
Sometimes your lordship is taking.
you said it was in the court. I thought it was in the court. I believe that it was. Hey, what a department chole geche, Mr. Mukherjee file.
Of judgment.
Yes.
Friday is the delivery of judgment.
My lord, I'm praying for not this week, my lord. My lord, the learned senior is out of station, my lord.
Yes.
My lord, I'm praying for not this week. My lord, the learned senior is out of station, my lord.
Please start. Please start. Yes.
I don't have the instruction, my lord. Kindly, my lord, not this week, my lord. My lord, kindly make it not this week, my lord.
The learned advocate appearing for
It's 12. 12. Get to.
My lord, I appear for the petitioner, my lord. Now, this revision has become infructuous, my lord.
it has been submitted by Mr. Bhattacharya. Oh, yes. Yes.
Lordship, my lord, I am challenging an order dated 10th of February 2026, my lord, passed by
10th
the
of
learned
February 2026,
lordship.
passed by
The learned fast track court at Barasat, your lordship, in connection with a section 24 proceeding. May I just briefly
Section 24 Hindu Marriage Act.
Hindu Marriage Act, your lordship. May I just give a very brief summary of the dispute, your lordship.
You are the wife of the husband.
I'm the husband, your lordship.
So you want reduction of
Lordship.
the amount.
Lordship.
What is the amount which has been directed to be paid?
15,000. My lord will find the order at page 184.
184. You have
186.
not annexed the certified copy.
Lordship, I have. My lord, the entire certified, all the orders, my lord, have been annexed. My lord, if kindly. Lord, after 211, your lordship, my lord will find the entire set.
The way now you are annexing the certified copy is very difficult to
My lord, this is
get the certified copy.
the certified copy. So,
Yes. 10th of February 2026.
Lordship. Lord, I have annexes also at page 184. My lord, she is already, to cut short the matter, my lord, she is already getting rupees 10,000, your lordship, in connection with a proceeding under, my lord, Domestic Violence Act.
So I will direct adjustment of that with this amount.
Your lordship, that amount has been directed by this honorable court only, because the lower court, your lordship, if my lord may, I just kindly give my lord a very brief summary.
Please give me a minute.
Lordship. ঠিক আছে।
You have retired.
Yes, my lord. Way back in 2012 and 2016, the DV proceeding was instituted by the wife.
At this point of time, you want divorce.
Your lordship.
The retirement.
My lord, in 2019, my lord, after she has instituted the proceeding under DV Act, your lordship, I have instituted this divorce proceeding, my lord.
If 15,000 is a reasonable amount, only one thing that can be done is the amount which you have been directed to pay under the domestic violence, that can be adjusted.
Your lordship, my lord, what weighed with the learned court below, your lordship, that I am incurring expenditure at rupees 15,000, so she also should get the same payment. My lord, she is already getting 10,000, my lord. My lord, kindly set off the amount, your lordship.
But what is the stage of the matrimonial suit? There is no caveat. Where are the parties?
My lord will find, my lord. अरे भाई सूट करना है
5, yes.
Item number 5, I appear on behalf of the petitioner husband, my lord. My lord, suit for divorce under section 13 of the Hindu Marriage Act on the ground of cruelty and desertion, my lord. My lord,
What is the order which you are challenging?
my lord, the condonation of delay of 277 days in filing the
What is the miscase for?
miscase for the wife, in spite of appearing in the matter, my lord, chose not to appear in the interregnum period when the suit was continuing, my lord. Thereafter, after the suit was disposed of by passing a judgment and decree in favor of the husband, after a year, more than a year, she files an application under Order 9, Rule 13, claiming that the advocate did not communicate her about the date of appearance, my lord, date of which was given in the dates, my lord.
Section 5 allowed 227. Can it be interfered with?
My lord, that cannot be an act of generosity, my lord. My lord, kindly seize the conduct,
No,
my
not
lord.
a question of generosity. Once the discretion has been exercised in one way, 227 can it be interfered with?
My lord, kindly seize the way
There
it has
are
been.
you have judgments in your support. If there are two ways. If the discretion has been exercised in a manner rejecting, yes, but allowing, there are judgments against you.
My lord, order passed, the application.
No, once discretion has been exercised in favor, allowing section 5, can it be interfered with under Article 227? What's the position of law now? I'm asking you what is the position, then I can go into how the discretion was exercised. If it is exercised in favor of allowing section 5, can it be interfered with under Article 227? Mr. Nayak, I think it can be expedited. Otherwise, it will be kept pending here.
Decree in the year 2024. Ex parte order in the year
Mr. Nayak, it will be kept pending here. Please understand this. Because after this, whatever will be done this way, that way, then if it is in your favor, it's well and good. If it is against you, then from there, you'll be losing, might be some days, or it can be expedited. I can expedite the hearing of the miscellaneous case. Ashwin, Mr. Yes, please show me what is the infirmity in the order.
My lord, the section 5 delay was sought to be condoned on the ground that the learned advocate did not inform the petitioner, the opposite party, about the date fixing the suit. My lord, whereas in the impugn order, my lord, the order has been passed, my lord, stating that it was the duty of the husband to inform the wife about each and every date of the case, which was passed in the.
Where is that?
My lord, kindly seize the impugn order, my lord, which commences from order number 11th March, 11th May 2026, my lord. My lord, last paragraph, my lord. My lord, second page, my lord, second last page. In the course of hearing of the parties, it is revealed that the petitioner wife is residing in the same house, my lord. I don't know from where the learned judge came to this finding. When the OP husband is residing, it is revealed that the case was filed for divorce under section 13 of the Hindu Marriage Act on the ground of discretion and cruelty. It is submitted that the learned advocate for the petitioner that the petitioner wife is still residing in the same house and the OP husband has obtained ex parte decree by committing fraud upon her and by concealing the status of the case of the date fixed in the said case. It is also submitted that there is one girl child begotten from their wedlock and the petitioner wife is residing with the said girl child and in the way and any way passing her days as the OP husband has not paid her any amount to her, considering the submission of both sides and having regard to the fact that original matrimonial has been filed for divorce on the ground of cruelty, desertion, though it is absolutely clear from the
By the order impugned, the
Continue.
Yes. Six, my lord. The instance are substituted dependents. Order under challenge is 23rd June 2026. This original defendant is a tenant and the opposite parties are the landladies. My lord, the original tenant after this.
What is the order under challenge?
Order 23rd June 2026, my lord.
23rd June.
Yes, my lord.
What happened by this?
My lord, after receipt of the summons by the substituted defendant on, they appeared on 22nd 5th 2026, summons received on 8th of May 2026. After receipt of summons, within 1 month, they have filed the petition under section 151 CPC for deposit of all arrears of rent and subsequent rent month.
When did the tenant die?
Tenant died, my
When
lord.
the suit was filed.
On 16th.
When the suit was filed.
Suit was filed, that date is not with me, my lord. When the plaint was filed. But tenant died
So
on
the original tenant, he entered appearance.
Entered appearance within time file 7172 that was disposed allowed, and till he was alive, he deposited all arrears of rent. As he died on 16th of May 2024, and he deposited the rent till the April 2024, my lord. After that,
where is the initial order under section 71?
Section
7172.
71, my lord. I have annexed all the orders, my lord. That is order, my lord. Order dated 2nd of April 2024.
2nd of
April 2024, my lord.
This amount was deposited.
Yes, my lord. Till he was surviving till April 2024, he was deposited the rent. After there was a demise on 16th of May 2024. I have annexed the challans, my lord. Challans page 29 to 31, my lord.
After substitution, when the summons was received?
Received on 8th of May 2026. I have filed the track report, my lord. Track report from page.
And you have filed this application when?
22nd
May. 22nd of May.
Yes, my lord. Within 1 month, my lord. And not only that, I
the learned advocate appearing for the petition may be justified Next.
Lord, husband petitioner in connection of a matrimonial suit. In the trial court, wife filed.
You will not pay alimony.
I am husband. I am not paying any. Yes, we are paying alimony in another proceeding, not in. Yes.
That is why I asked you. You will
Yes,
not pay
yes,
alimony.
obviously.
So what is the dispute? What is the order under challenge?
My lord, in our suit, my lord, in my suit, my lord, they file an application for maintainability of the suit. Although they file written statement that court in pending before the Barasat.
What happened to that application?
That application pending last year for 1 year more.
You want expeditious hearing of that? Ashwin.
Not only that, my lord, in that suit, my lord, they also file another application for maintenance, particularly when that suit is not maintainable. Our suit is not maintainable, but
that is one thing. But till the suit you are harassing her, she is entitled to alimony.
the client is paying, my lord.
She wants something more than that what you are paying.
Already
This
paid
application
27
under article.
My lord, already paid 27 lakhs.
in DB proceedings.
Quantum does not matter. That will depend upon your status.
Masters in
This application under Article 227 of the Constitution of India is at the instance of the husband praying for a direction upon the learned additional district judge, fourth court at Balasat, to dispose of the when it is fixed those applications
On 18th August.
to dispose of the application 18th of August when it was filed.
Last year, my lord, on 5th
To dispose of
July
the
2024.
To dispose of the application challenging. What is the miscase for?
Miscase, my lord, I am saying that miscase for that for again they are paying for maintenance, my lord. Again.
No, miscase is for maintenance.
Yes.
On that 18th of August has been fixed. Where is the matrimonial suit? 18th?
Same day.
No, where is the order sheet of matrimonial suit? For cross-examination of PW1.
And see the top matrimonial and miscase.
But 18th of August, it has been fixed for further cross-examination of PW1. It's not for hearing of application.
Blood application.
The order dated 15th of June
Your lordship
does not speak of any application. When that application was filed?
My lord, kindly order number 20.
Yes, I am at order number 20. This does not refer to any application challenging the maintainability.
No. It is that application is on taking evidence regarding the maintainability.
Evidence?
Yes.
Lordship, if I may add here, Lordship, the thing was they had filed a maintainability petition challenging. Thereafter, the learned trial court framed preliminary issues on the land, and thereafter the evidence was being conducted, Your Lordship.
Your lordship, kindly see order number 19th and 18th.
Evidence on maintainability point.
Yes, Your Lordship. Yes, Your Lordship. And
and already wife has been examined as a PW1.
You have not challenged those orders. Want the application to be disposed of. Ashwin. This application under Article 227 of the Constitution. 8, yes, who is appearing?
Item number 8, I have the instructions to appear on behalf of the opposite party, my lord.
Yes. What is the can for?
The can, my lord, they have served a section 5 in connection to, my lord, this order, my lord, probably is setting aside abatement, my lord. This is an appealable order. That has been rejected.
Order 22,
Rule 9.
miscellaneous case has been dismissed.
Yes. That is in connection to, my lord, order 22, rule 9.
But where is the petitioner is not here? None appears for the petition at the time of call, no act. By standard advocate. Yes, next.
Yes, item number 9, my lord, I am for the petitioner. My lord, this is filed for expeditious disposal of the execution application of the petition.
But opposing that.
No, I don't know what is the CO about.
Just hearing
Disposal
of
of the
the
execution application.
If a copy
Pending
can be
before the
given to
learned
me.
Decisions hearing of the
execution application before the Learned Consumer Forum.
Consumer
Purulia.
Forum.
Yes.
Who are you?
I am the petitioner. I am the decree holder.
My lord, there are diverse proceedings, diverse orders which are under challenge. No, my lord, kindly allow him to serve, my lord, and then my lord, lordship keeps it any day this week, and my lord decide. This is not a simpliciter expedition. Can't be, my lord. Parties are fighting. There are at least, my lord, 15 orders passed by this honorable court in different COs.
It's pending before the National Commission also.
That's a different, no, not arising out of
10th of September for awaiting orders from the Honorable NCDRC.
that order, that matter is related to different consumer forum case.
That I do not know. It is in this.
What has
matter.
happened, my lord?
As a
Petitioner is
checkered
directed to
history,
serve-
my lord.
petitioner is directed to serve a copy of the Yes.
My lord, the judgment letter is the petitioner before your lordship. I have suffered an eviction decree. I have preferred an appeal that was dismissed for default. Restoration is pending. Now,
Restoration pending.
yes.
Now the execution is at what stage?
Please help
Allowed.
out, and lordship writ has been issued. Challenging these two orders have come up before your lordship. Now, lordship, in my earlier also, lordship, this is the second round of litigation.
Restoration application, Mr. Rai, I am directing the restoration application to be decided within a
If
certain
this is
time.
the conduct of the judgment letter asking for stay of the police help order, then I'll not utter a single word. How the bailiff has been treated, confined in a room, beaten up, the court take. If after that one, I'll not utter a single word regarding execution. বেলিফকে ঘরের মধ্যে ঢুকিয়ে মেরে চামড়া গুটিয়ে দিয়েছে। That is the consideration for the court will executing court to execute. What prompted her not to take steps for restoration of the appeal?
No, we are taking steps.
Yes.
Last order, এই গ্রাউন্ডেই অ্যাডমিট হচ্ছে।
Please give a copy to her.
Now, lordship, kindly sees the
And previous order passed by your lordship.
Yes, yes.
Says 36.
36.
What order did I pass?
Setting aside the order of police on the ground that no application, the application has not been forwarded to my learned friend. That is why your lordship is pleased to set aside that order, remanded the matter, direction for first consideration of giving opportunity of hearing.
Yes.
Such opportunity of hearing was given.
Was given.
And the court is now, my lord, is your lordship considering whether this police has been corrected. On the basis of the facts which I have stated for your lordship, whether the police order can be granted or not. Then to what extent the bail will be registered, after that the police will be granted. 19 years already passed, 2007 degree was passed.
Yes, now the copy was served upon you.
Yes.
Now what is the infirmity in this?
The written objection that is at page 40. I specifically stated that lordship on that day, they lordship assaulted me. Lordship, kindly see at page 41, paragraph 9. And I had to be hospitalized for that. because they brought Lordship goons from outside and they beat me up, Lordship.
So that is the decree holder. Decree holder have,
Me.
yes, decree holder has a,
Lordship, in the support of that, by way of fiduciary Lordship, I also submitted documents. That is at page 47. Lordship kindly sees.
yes, FIR has been registered. So that will, Mr. Chakraborty, that will proceed in its own way, because I cannot decide on the veracity of that. Now,
This help was allowed. Lordship, can you
yes,
please the order impute?
yes, 16th of July.
16th of July, Lordship.
Yes.
The second last paragraph, the learned advocate for the judgment debtors raises strong objection to these allegations and submits that the decree holder and his men and agents created a threatening situation and breach of peace, due to which he had to complain to the local PS, and as such the prayer is liable to be rejected. There is no document submitted by the judgment debtor. And so based on that, believing their story, the learned trial judge, Lordship,
The police will not go, my lord. Police will not go.
This is a feed case where the police should go, because both of you,
Yes.
to control both of you, police should go. I think the local police station will not be competent. Something higher officials should remain.
It was us. Police was requisitioned from Khanapur.
Case where both of you, so both of you, it's to control police is necessary. It's not an ordinary case.
Were supported by documents. The learned trial, the learned executing court
So
documents.
to protect you, police should remain there. More so that you are not hurt on the next day, police should remain there.
And the
Mr.
Calcutta.
Koti, and also Mr.
Paracetamol.
To protect both of you, or in the other alternative. Now the decree is staring at your face.
Now, man, the protect
Hand
the
over
belief.
the possession. I appoint an officer of this court as a receiver. I appoint an officer of this court as receiver. Please hand over the possession. Then 144 is there. You fight it out.
My lord, my lord.
Get it. 144 is there. You succeed, you get back possession. You get back possession. If you want, I can appoint an officer of this court as a special officer. I'm fixing a date here and now. Please hand over the possession. You fight it out. 144.
Grants me some time. Lordship, we can vacate. The thing is that
When you can vacate?
no,
Please
my
give the time.
my client's daughter's marriage is due to be held on January.
January is far.
Lordship, Lordship, this is a
Chakraborty, January. Miss, you have the plea which you have, Mr. Rai. What do you say? If this is the fact, if she gives an
This undertaking, my lord knows very well what is the effect. Kindly because after this passing, after this incident, whether my lord will allow. Kindly because today is the incident is such.
Only Mr. Rai, only the submission. I'm not on the other thing. The submission, the ground for which she is praying for time. I'm asking you, can you take instructions and come back?
We have already purchased another place, Lordship. We have to set out the shop there, Lordship. So give us some time, because the marriage of the daughter is also there.
Ms. Chakraborty, you are taking twofold. One, you are saying on one hand, you are saying daughter's marriage. On the other hand, you are saying shop you have purchased.
No, not shop. The land we have purchased where
After
we
construction.
intend to stay. But Lordship, now my daughter's wedding is also near, Lordship. So give me some time.
This is a residential house or the
No. Shop room.
Commercial, Lordship, a cosmetic shop, Lordship. Lordship, kindly.
Sir, if they January is far off, Ms. Chakraborty.
But Lordship, for them, Lordship, now he has purchased the land. Now she has to give marriage to the daughter. Some
After that, my lord, you have to build up the shop. Then my lord shifting comes. Yes.
that is the practical approach. Lordship.
Yes, that is what, my lord.
After all, he is just
I'll not understand if after this, my lord.
The ground, Ms. Chakraborty, which you have taken, Mr. Rai is also thinking of that now.
Yes, we should remember. We need to think about all this.
Mr. Rai, can you take instructions and come back on this?
That's it. Yeah, কথা বলুন। Yeah.
I'm passing it over. 12 or 2 p.m. or 1. Mr. Rai, you can take some time to take instructions. 12 or 2 will be suitable.
One, Lordship. 12, I have a matter fixed now.
2 p.m.
PM also there is a matter fixed.
For 10 minutes, my lord, I'll come back.
Then 12. Mr. Rai, do you have an extra copy of this? Please give it to us.
Yes.
এটা দিয়ে দিন, or you get it photocopy in the meantime.
একটা copy আছে তো extra?
500 টাকা করে রাখুন, 12টার সময় রাখুন এটা।
দেখেন।
Yes, call the next matter.
Lord, my application, my lord, order passed by the DRT, but I will not trouble. I will not trouble. The mischief has been committed.
Mistake has been committed.
Mischief. I've been thrown out. My lord, now kindly takes the impugned order for once. I'll seek a very innocuous order. My lord, kindly takes the impugned order at page 113.
113.
Mark করেছে কি? এটা? My end.
Order dated 2nd of June 2026.
June 2026.
Yes.
Now, there was an application at my end saying that the section 14 order was not served upon me. So there was an application for service of the section 14 order and not to dispossess me in the meantime. That was the sum and substance of the application. Now, Mullah kindly sees the impugned order. Mullah see the judge records it. It has been filed for issuance of a direction to the bank not to take physical possession of the property without giving due notice to the applicant, and also for a direction to the authorized officer UCO Bank to provide the copy of the order of the learned DM South Chobbish Program. This is my application. Now, Mullah kindly sees the next page. Page 114. It has been stated that possession order was issued on 24/12/19 and by a further memo dated such and such, wherein one such and such was appointed authorized officer to take up possession. So this was Mullah there. Now Mullah kindly sees the third last paragraph. It has been submitted the initial order dated 28/6/18 is not reflected in the letter dated 21/5/26. So only second order is reflected. So Mullah, there was a series of orders. Now Mullah learned counsel. Now Mullah kindly sees this. Learned counsel for the applicant submits that she will go through the documents filed on behalf of the defendant bank and then will file opposition. But there's a mistake. It should have been the other way around. Learned counsel for the defendant submits that she will go through the documents filed on behalf of the applicants and will file opposition. Now Mullah kindly sees the hearing of the IA is deferred to 27/6/26. On that day, Mullah hearing did not take place, and Mullah now the matter is now posted on 26th of November 2026, and I'm out. I'm out of possession. Now Mullah kindly sees
possession has been taken.
Yes. So Mullah, now what is the problem? Mullah, on 27/7/2016, when they were supposed to hand over the opposition, kindly sees there were the directions. Mullah, kindly sees the next paragraph. It has been submitted on behalf of the defendant bank that
was served and the order passed was also served.
This is what they say.
Yes.
Then Mullah kindly comes. All preparations have been done for taking physical possession on 3/6. As the impugned orders are not available, the proper appreciation could not be made. Now, Mullah, these are documents of the bank. The bank obtained the order. Mullah, if the bank does not come with the documents, Mullah,
as the principal officer, as the principal order under section is not available, the defendant bank is directed to place the order on affidavit.
Yes, Mullah, now this is what I am on. Mullah, now these are documents of the bank.
Matter shall be heard on the next date,
which was 27/7/2026. It was not heard. No opposition filed, no affidavits filed. It's now posted on 26th of November 2026. And I'll be out of possession for so long. But just visualize this thing, Bullet. The section 14 order, which I say was not served upon me. So this was...
Bardhan, it's better you take out an application before the DRT, pointing out this fact, because it's the DRT who has said that it will be taken up on another date. Please point out that
27/7 date was fixed.
Yes.
Now the next date is fixed on 26th of November.
For preponing that, because Mr. Bardhan, you have to say that by this order,
I appreciate.
In violation of this order, this was done.
Well, now I have to couch the relief. So Murad kindly permits me to do that and let that be taken on expression basis, Murad. That is the limited. Otherwise, Murad, I am out of possession. And Murad kindly sees this.
But without the bank...
Mullah, it's an innocuous order for express disposal, nothing beyond this. Mullah, and kindly sees the anarchy, Mullah. Section 14, I say not served. My lord, it's a document of the bank, my lord. Now the bank is not ready with the document. The bank says he's not ready with the document. The court says is the principal order is not before the court can't adjudicate. So may I pose this question to myself?
When possession was taken?
It should be on third, because possession was supposed to be taken on 3rd of June.
Yes, when it was taken.
It should be that day, my lord. Should be that day. Because
On that date itself.
Yes, should be, my lord. Because on 2nd of June, I don't have an interim order. 2nd of June, this
interim order was also not passed.
Why? Kindly sees the reason. Since the document is not before the court. Now, whose duty is to produce those documents? negotiate. My lord, we had to, my lord, change the prayer, my lord, having it.
Next.
I'm grateful, my lord.
Yes.
It is my application, my lord. I think I have not received any caveat, my lord.
Well, I'll just indicate today the matter was there before DRAT. So that time I got to know that it is appearing as item number 12 today. So there they have prayed time because this revisional application is.
Please give them a copy.
My lord.
Yes, what is this? What
My
is
lord,
this?
at the very outset, I should be very candid, my lord, that the learned chairperson of the Honorable DRAT has showed amnesty, has given me, showed his benevolence, my lord. He has granted 25% of the.
From 50 to 25%, it has been reduced.
Highest. Reduced.
Highest.
Lowest is 25% and reduced. But my lord, my point is on a different aspect.
You are agreed by that?
No, I am agreed by the amount on the calculation. My lord, my contention is this.
No, according to you,
the amount should be on.
If 25% is calculated, there has been a wrong calculation on the amount.
No, my lord, I'm coming to that. My lord, the amount was calculated on the figure shown by the respondent bank as of date 20 crore something odd.
Yes.
But according to me, my lord, the calculation should be on 12 crore. That is the amount mentioned in the 13-2 notice. Because my lord, kindly sees the provision, my lord. Just for my satisfaction, I'm reading it out.
As per the notice under section 13(2), date due is 1290.
1290. It should be on that, not on 20 crores as produced by the respondent bank in their affidavit. In the respondent bank, in their affidavit, has said it is 20 crores as of date. So
you are the bank.
No. Yeah, bank.
I thought that you are for the bank because you regularly appear for the bank. That is why I failed to understand how you are agreed by this. Because if they are directed to pay deposit higher amount, how are you affected? That is why I could not make out. Yes, sir. What do you say?
Well, I'll just indicate. Let my learned
If this is that, you can approach that with regard to the calculation.
Not calculation, because they have shown it is 20 crore as of date. They are saying this 20 crore is due as of date. And the learned chairperson has directed me to pay 25% of that 20 crore. But I say, my lord, it should be, my lord, I am a cancer patient. The petitioner is at a very critical stage.
My lord, kindly
Considering all
consider
this
this
aspect,
judgment
25%.
Because my lord, I would I have all compassion. But my lord, after this judgment, here it's clearly says that
paragraph
as on
13.
the
I will not trouble my lord to see the entire judgment. And this is paragraph 13 of this judgment.
Paragraph 13.
13.
Yes.
My lord, as per 2HA of the Surfacy Act, date shall
Paragraph
have the
13.
same 13. 1-3, my lord.
Yes.
As per section 2HA of the Surfacy Act, date shall have the same meaning assigned to it in clause G of section 2 of the Act 1993. As per section 2G of the Act of 1993, date means any liability inclusive of interest which is claimed as due from any person by a bank or a financial institution during the course of any business activity undertaken by the bank or the financial institution in cash or otherwise, whether secured or unsecured, or assigned, or whether payable under a decree or under any civil court or any arbitration award or otherwise under a mortgage and subsisting on and legally recoverable on the date of application. The date means liability inclusive of interest. My lord, now I come this sub paragraph. As per section 18 of the Surfacy Act, any person aggrieved by any order made by the Debts Recovery Tribunal under section 17 may prefer an appeal within 30 days to an appellate tribunal from the date of the order, receipt of the order of the Debt Recovery Tribunal. Second proviso to section 18 provides that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount of the debt due from him as claimed by the secured creditors or determined
so
by
13.2 and 13.4 the amount.
Yes, my lord. That is my contention.
Yes,
and
what
here
do you say?
admittedly no sale has taken place. No sale has taken place.
Kindly see paragraph 16.
16.
Yes, my lord. 16 and 17. May I just please? in view of the above and for the reasons stated above,
Yes, in view of the above, yes.
for the reasons stated above, in the present case, the respective High Court has seriously erred in directing to adjust and appropriate the amount realized by the auction sale of the secure property.
Here there is no auction sale.
Kindly appreciate
Yes.
what yes. Auction sale by the auction purchaser while considering 50% of the amount as pre-deposit to be deposited by the borrower, while preferring an appeal before discovery. Even the High Court of Delhi has erred in excluding the amount payable towards the interest. Kindly mark this portion. Excluding has erred. Even the High Court at Delhi has erred excluding the amount payable towards interest while considering the debt due as per section 2G of 1993 Act. Debt means liability inclusive of interest as claimed by the financial institution bank. Here it comes, my lord, Honorable Supreme Court has clarified. I'm not on sale aspect. Here the sale didn't take. It has clearly clarified that when you are preferring the section 18 application, the due as on that day, which includes the interest part, that is what it has been clarified in this last 3 lines. And thereafter, my lord, see, in view of the above, my lord, have seen those 3 lines. In view of the above and for the reasons above, the respective appeals filed such as such are hereby allowed. Appeal preferred by the borrower against the judgment deserves to be dismissed, and according it is observed that the borrower has to deposit 50% of the amount debt due as claimed by financial institutions along with, kindly mark, along with interest as claimed in the notice under section 13(2), and the borrower is not entitled to claim for any adjustment apportion of the amount realized. My lord may skip over this portion and deposited by the auction purchase. So the Siddha Nilkant has 2 aspects. Honorable Supreme Court has clarified that if there is any sale, you cannot take the benefit.
Yes.
Another part is from 13(2), because my lord, once the 13(2) notice is issued, the interest accumulates on a separate book. It cannot be accumulated on the main account because the account has been classified as NP. Now, my lord, when you prefer an appeal, the interest that has accumulated has to be taken into consideration. That is what it has clarified in this judgment. That is the reason, my lord, when section 18 applications have been moved, what is the due as on date are being asked from the bank to produce before the court. Depending upon that, my lord, the highest reduction has been given.
No, that is the statutory that you are not aggrieved by that. You have not challenged. That's one part.
That is
Now
the-
this percentage will be calculated on what amount. That's the only subject matter now.
That's so Supreme Court has Honorable Supreme Court has clarified. Kindly see paragraph.
You have the
16.
Delhi High Court judgment, which
Yes.
has been taken note
Because
of by
no,
the-
that is what the Honorable Supreme Court has said. Even the High Court of Delhi has erred in excluding the amount payable
Yes.
towards interest.
So Delhi High Court's judgment. Do you have a copy of the Delhi High Court's judgment?
Delhi High Court of Yes, give me. Delhi High Court citation Delhi High Court citation accept.
Would include liability plus interest, date due. So
So,
interest up to which date?
Up to the current date, because debt due, firstly, it has clarified that the debt due, what is the debt due? Debt includes the interest as well. So, the Honorable Supreme Court, while clarifying this thing, has said that the
Please show me your opposition wherein you have said this figure of 20 crores.
My lord, I'm showing.
My lord, I don't have it. He has the copy. He may.
Yes.
My lord, at page 4, my lord.
Page?
Page 4. Page 4, sorry, my lord, internal page 4, it is actually page 76, my lord.
Running page 76.
Running page 76.
Where is that calculation of this amount with interest? Because the tribunal has taken note of that. I think I have considered this issue in one of the matters.
My lord has passed judgments wherein my lord has said that reduction of the percentage.
reduction.
Of the matter, my lord.
I think you appeared in that matter.
Couple of matters, my lord, wherein my lord has said 35. Yes, it can be. My lord has gone down to 25.
Yes.
So that is the discretion.
Yes.
Is the appellate tribunal exercises, which my lord also exercises. But the act says nothing can be below 25%.
So there in those matters, interest was not involved.
No. So there the total quantum was not in dispute. Because my lord, this judgment has clarified this point. This judgment, the Siddha Nilkant, is a celebrated judgment. Wherein my lord, 2 points has been clarified. Once the borrower cannot take the advantage of the sale proceed when he is challenging the sale.
Once you classify an account as NPA, can you charge interest thereafter?
That is what it is saying. That is what it is saying.
It's,
kindly clarify.
It's difficult. Then the amount cannot be a fixed ascertained amount.
No,
cannot be variable.
Lord,
It will depend upon the length of the.
No, my lord. Kindly clarify for 2 minutes. I'll just try and clarify this thing. Just try and clarify this thing. In Siddha Nilkant, what it has said is the definition of debt. Debt definition in terms of RDDB FI Act, that is Recovery of Debts Due to Bank and Financial Institution Act. Recovery of debt due to Bank and Financial Institution Act, that debt includes principal and interest.
No, principal and interest is interest up to which date? Whether interest up to the date on which NPA it was declared as NPA or subsequent thereafter.
Thereafter even.
I have been by my learned friend, I have been shown this judgment passed by by a division bench of the Bombay High Court, presided over by my Lord Justice Dipankar Datta.
Well, this is
what it says with the interest.
Paragraph 4. My lord, DRET was right in holding that what is less between the sum claimed by the secured creditor in the notice issued under section 13(2) of the SARFAESI Act and the sum claimed on 29th April 2021, that is the date of presentation of the appeal under section 18, had to be considered bearing in mind the lesser sum of the two demands, pre-deposit of 50% or 25% as the case may be calculated. However, in our opinion, the DRET erred in arriving at the correct conclusion because of a flawed procedure that is adopted, that it adopted.
All right, do one thing. Please give that citation. Let him also consider. I'm taking tomorrow.
Tomorrow, very good.
Please come back. Please give that citation because interest that cannot be a fluctuating figure. Depending on when it is.
This is Mohammed Afzal. What my lord is seeing right now of 2023.
Yes.
This is 21. And tomorrow I will clarify this portion, my lord.
If you have an authority on this, that yes, not on the amount, not on the date when it was declared as NPA, any subsequent, because can you charge interest after it is?
Siddha Nilkant has clarified. Tomorrow I'll place this entire judgment.
It says, look, it does not say after NPA you can charge interest.
No.
It's not an authority for that proposition. So the question is, unless you can charge, how can you say interest after that period? How can you
for that, my lord has to consider two things. There are two acts that is running side by side. One is a SARFAESI Act that is called a Securitization Act, wherein the
all right,
I'll come back tomorrow. I'll come back to the and clarify.
এটাকে রেখে দিন তো। Yes, Mr. Chakraborty, where is your counterpart? Where is Mr. Rai?
Coming, madam. However, my lord, I have talked with my client, my lord. As because Puja is knocking the door, my lord, let it be till Puja, my lord. I have no objection, my lord.
Till Puja.
Till Puja.
My lord, kindly
That
see.
is, my lord.
I'm coming after 5 minutes. agreeable to that. If you can agree up to puja, please. sit
Lordship,
at the-
day after day, they are taking time in the appeal. Lordship, kindly see.
All right, I will consider.
From March, every date they have taken
I'm
time.
coming after 5 minutes.
Lordship.
Yes, Mr. Rai.
Yes, my lord, I have took instruction from my client, my lord, from advocate, my lord. After puja, my lord, we had agreed. Now,
My lord, kindly see
She is not agreeable with that.
the order sheets. Lordship,
Yes.
March onwards. On each date, Lordship, they have taken adjournment.
very well.
This copy was supplied by them to me. It is
Yes.
not, this is also supplied by them.
Kindly consider the first order in title appeal number 8/5/2023. 8/5/2023.
No, this case is for restoration of the
Restoration and dismissal. First come dismissal.
No, after dismissal, because after your lordship's order, what happened? Day by day, they are taking adjournment, my lord. In all dates, they have taken adjournment, my lord. Except one date, when I have filed some documents by Firisti, and I intimated about death of a person.
Yes.
And now lordship will kindly come to the bailiff's report also.
Yes.
যশোরে একটা extra copy ছিল যে বললি যে?
Yes, where is the bailiff's report?
এই যে।
You have annexed.
No, I didn't have it, my lord. They have produced it. My lord kindly takes up the last two lines of the first paragraph. আমাকে ও ডিক্রিদারকে বেঁধে রাখার হুমকি দেন and ডিক্রিদারকে মারধর করার হুমকি দেন. So it is not a case that we bound them or we just assaulted them. All we did was we gave them humki. Now lordship kindly says what they did to me.
After that.
যেহেতু শান্তিভঙ্গ ও শান্তি আশঙ্কা থাকায় অতঃপর
শান্তিভঙ্গের আশঙ্কা থাকায়
yes, he could not execute the writ.
After that.
Thereafter, police came since উল্লেখ থাকে যে উত্তেজনা চরম পরিস্থিতিতে পৌঁছলে পুলিশ বাবু উপস্থিত হন এবং পরিস্থিতি নিয়ন্ত্রণ রাখিলে আমিও ডিক্রিদার উক্ত স্থান হইতে বাহির হই. Now lordship kindly see what my allegations were. I need not even read them out. What they did to me. At page 48.
48 of the revisional application.
Yes. They assaulted me, took away my money, everything.
Then my lord, she is admitting his poison has been, she has been dispossessed.
No.
After money has been taken away from her shop room.
The bailiff himself is saying that
Yes.
tell your possession.
Chakraborty, the both of you are apprehending breach of peace at the time of delivery. That's a sufficient ground for 208.
True, but lordship in the appeal, day after day, they are taking adjournment, lordship. What can I do?
My learned friend is submitting, my lord.
What is the stage of the miscellaneous case?
Only lordship, an application is pending for substitution
order.
hearing. Lordship, that
There's
is
something must be limit. There must be some limit regarding protecting the litigation.
2023 what order?
The title I will file. One by one, my lord, I am satisfying your lordship.
From where are you placing?
The bunch which I have handed over to.
This bunch. This bunch.
No, we can order গুলো দেয়া আছে তো. Oh.
Yes.
No, order sheet. Title appeal.
No, title appeal is that was dismissed for default.
How many days? 6 times. Court ultimate. So therefore, my lord, it cannot be said that whatever time this suits them, then they will come up and fighting the litigation.
We filed a written objection against the police help lordship. They have taken time. All the in all occasions.
That means they are entitled to resist the police and the bailiff.
No, they don't want my appeal to be that restoration to happen.
What prompted my learned friend not to take steps while the appeal was fixed for hearing?
Say lordship, that cannot be considered here and now.
Yes. So today, my lord is restricted to the order passed by the executing court regarding granting of police help.
It is their conduct also, lordship. Even my appeal is not getting restored for that. Day after day, they are taking adjournment.
For expeditious disposal of the miss case, that's one thing. Now it will not. Now it will not end. Now it will not end with the merely on the restoration. After restoration, then the title appeal gets restored. Then what will happen? Restored or not restored? So best thing.
Since 3rd of September is the date fixed. At least till then, Lordship kindly protects me. If I can restore it on that day and Lordship directs the learned appellate court to hear out the matter, then if I can restore it, I can pray for stay there, Lordship.
So is it the section September? What is the date? 9th September is for what?
So next day in the my restoration proceeding.
No, execution also.
9th September is the execution.
Lordship kindly sees the last day of the order sheet I handed over.
31st August.
31st of August.
Yes.
No, the order sheet, this order sheet.
Yes.
This order sheet.
Restoration case, Lordship. The next date is 3rd of September.
2nd of September.
2nd of
For
September.
hearing of the petition filed dated.
That is a substitution because one of the parties died. I have to, Lordship, file substitution. Late on that day, Lordship, everything we heard. If it is restored, then I can go back in the title appeal.
No, what is the use of filing this execution? After disposal of every proceedings, after second appeal has been filed,
they are
whatever is admitted or not, why not kindly consider? 2007 degree passed. 2026, still I am not able to enjoy the fruits of the degree. On the basis of the conduct of the.
Restored because of his conduct.
Yes, and it was dismissed due to my latches.
Maybe, but
maybe. That is maybe. So as of this day, my lord is confined to the order.
The only one thing, I have to go by this order. I have to only see whether what infirmity is there in this. What will happen in the other proceedings?
This is the reason
Please show
why,
me the infirmity in this.
Lordship,
this order.
the reason why, Lordship, police help was allowed.
Yes.
Lordship, the second last paragraph, Lordship.
Yes.
The learned advocate for the judgment debtor raises strong objection to these allegations and submit that the decree holder and his men had created a threatening situation and breach of peace, due to which he has complained to the local PS, and as such, his prayer is liable to be rejected. There is no document submitted by the judgment debtor. But Lordship, I have shown that Lordship, this by way of fideisty at page Lordship 47.
Mr. Rai, do you have the rule 208?
In apprehension, I did not give notice to my learned friend.
Yeah, civil rules and orders.
My lord is thinking about the Justice Ray's judgment. 2197, it is not 2197. It comes in the purview of 208. There is satisfaction of the court regarding there is a chance of breach of peace. That is enough for granting police help.
That is not the reason, Lordship, given.
Yes. What more after the death of the bailiff?
There was no such situation. I just threatened them.
Oh, yes, he has threatened them.
What they have done to me.
For your protection also.
Yes, it's necessary.
So for protection of both of you, it's necessary.
But Lordship, the learned executing court totally, Lordship, ignored the document submitted by me.
Please give me, that will be better. Supporting the order. Both parties
are apprehending.
That is your police complaint.
Yes. Lordship,
I think that will support the more the police help. Page.
48, Lordship.
এটা কবে বললো? Which is that what? হ্যাঁ? এটা আবার কবে হলো? Date of occurrence? সে কি? My lord, kindly consider page 48.
48, the written complaint?
Yes.
Don't read it loudly, Mr. Rai.
Last page, 49, date.
Don't read it loudly.
No, date. My lord, kindly consider the date. No, very well. I'm grateful to my learned friend. Page 49, my lord. Kindly consider page 49.
Yes.
The date is 29/8/2025. My lord, got it?
Yes.
I don't know why this medical certificate has been annexed. Probably out of this assault, And turn to page 50.
Yes.
Date of occurrence,
Yes,
Date of occurrence.
left hand top, 13/8/2025.
what it is written, the third line on 13th of August. I was so gravely injured, I could not.
And this complaint was filed on 29th.
Yes,
After 15 days.
Yes.
Well, can you consider there must be some limit regarding this abusive process of law.
but it was submitted in the court in November 2025.
No, what happened on 13th of August was the date fixed
Yes,
on that date.
And 29th complaint was lodged.
Yes.
Chest pain, paracetamol.
no, he was also referred to that medical college, PCC and medical college.
Headache and chest pain. ভালো করবি তো একটু।
Mr. Rai, where is your application under 208?
Yes. That your lordship will find at page.
No, no,
না না কার মানে আমাদের তো তার
এটা একটু দিন যশোরে দিন।
অ্যানেক্স করে আমাদের আলাদা কপি আছে যশোর দেখি ওই একটা কপি ওর মধ্যেই আছে ওই সেটের মধ্যেই আছে আমি বার করে দিচ্ছি My lord, I have handed over a bunch of documents my lord will find because it is not been annexed.
Yes, yes, it is there.
You have got a copy.
Only I have indicated the incident.
When the decree was passed,
2007.
Where do I get this?
30th
Chakraborty, you have stated this in the petition. Where do I get this?
Yes, my lord, the list of dates is there. My lord,
Right, updates in the
revision application. Yes, Mr.
comprehensive one.
Mr. Chakraborty went to comprehensive.
No, I did not.
30th March 2009. My lord got it.
Yes. Then title appeal in 2024. 2024. Dismiss for default.
Yes, after 15 years.
Dismiss for default. Then
Miss case in 2024 itself.
13th August 2025.
Bailiff visited the property.
stay application filed in the title appeal.
Yes, rejected.
Stay application dismissed. When?
Yes, I have that bunch of order I have handed to your lordship.
Stay application dismissed.
Yes, not taking steps. 5 times adjournment was granted. After that, my lord, can you consider the conduct? After considering the entire thing, my lord, it was rejected. My lord, may I hand out, find out the copy from the bunch of the documents? I'll hand it to you.
Put a tag mark.
Yes.
But after
When the application
it was filed, lordship, I am very much diligent.
Very much.
Yes, on each and every occasion I have appeared, my lord. It is they who are now taking time, lordship.
I will expedite that. Next step.
But lordship, before this, lordship,
Order number 91.
just one chance, my lord, because lordship, till the next date. The next date there is 2nd of September.
I am
Then
not inclined.
if the execution be stayed till then.
91, page 91. Order number 91. What steps in it?
Then lordship, it was not rejected on merit
The expiry degree have some different meaning and context.
at all. But still, lordship.
And after that, adjournment also read for by the appellant. It is not that after that they became diligent and contested the appeal, nothing that.
After lordship restoration was filed, we became lordship vigilant. And after your lordship,
If I go in details of these orders, Mr. Chakraborty, it will be difficult for you to get it restored.
second,
The
lordship, second.
the order sheets which are here, it's Ashok.
2nd of September, Lordship. That is the date in the miss appeal. Miss case, Lordship. Till date, the Lordship.
Conduct, Mr. Chakraborty's.
But they are seeking adjournment, Lordship, in the
I will
miss-
expedite this.
Yes.
No document.
Not before, Lordship. If I am
144 is there.
Lordship, that
Is
is
the-
always there, but my client will lose
More
interest.
than
Where will
it,
he
you will
go?
be vigilant. You will be interested in succeed in the suit. What was the suit for eviction on the ground of?
License 106.
106. You have a very good case in the appeal. Please fight it out in the appeal. This application under Article 2.
This is the separate land. My daughter's wedding is Lordship near. Lordship.
Chakraborty, that
Something
what can be done?
if I don't want to place all these things before your lordship.
Uh,
This is the incident occurred on that date and how it has been handled. I did not.
This application. Only one thing, Mr. Chakraborty, that police self-application, I'm
Yes, 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 yes.
Do you have an extra copy of that?
Yes, yes, yes. Yes, it is kept in the record. Why not? That
No, whether she has, because she has given, if she does not have, please make a photocopy and give it.
what are that?
Yes. Yes.
The opposite party of the landlord lordship, they file a suit for eviction and recovery of house position against this petitioner. Later on, lordship, the petitioner has filed the WS along with the sections 7.1 and 7.2 application along with section 5. The only lordship I know. The only two grounds is there, lordship, because the latches on the part of the erstwhile advocate of the defendant, they could not fight.
Ashun.
Passed by the DRT. And this, Muller, I'll argue with some earnest. Kindly takes the impugned order for once.
Sir,
This
there is an appeal.
This transgresses all judicial propriety. Kindly cease. I file a section 17. During pendency, they issue a sale notice.
Who are you?
I'm borrower.
Yes.
I file a 17 application. During pendency, Millard, they issue a sale notice. I challenge the sale notice by way of an IA. Admitted position now. Now, the sale was supposed to be held on 21st of July 2026. Admitted. I filed the application on 12th of July 2026. The matter was taken up on 20th July 2026, one day before the sale. Kindly now seize the order.
What happened?
says the learned counsel for the defendant, such and such, submits that the bid process is in process and one bid has been issued. As the auction is undergoing for the sale scheduled tomorrow, that is 21/7, post the matter for hearing of IA such and such on 6th of August.
What happened thereafter? Sale done.
I'm not
Or
aware.
it failed.
Sale
Not aware.
confirmed,
This is for bank.
sale confirmed, sale certificate issued, possession has been given up, my learned friend, there is documents.
It had been taken by me earlier.
No,
From me
no,
earlier.
no, it's after the sale was confirmed, the notice was the sale was supposed to be, to take
was
place on
the-
21st of July.
What was the use of fixing on a day subsequent to the auction?
I am not on
My lord, this was heard, it's impliedly rejected. My lord,
Show me that.
my lord, the order did not say so, my lord.
Then
This is a self-created urgency, my lord. My lord, kindly hears me, my lord, kindly hears me, my lord.
Yes.
My lord,
Please show me the order.
Yes.
Kindly seize my lord, the
Now, my
last
lord,
page, my lord.
Page.
after everything has happened, my
Include
lord,
order, my lord, the certificate
none of the
copy,
press survive, my lord. Can you
After-
see? None
after
of the
page
press survive.
258. Be after page 258.
After page 258. So there is a limit to everything. It's the limit to everything.
Please seize, my lord, the last 4 paragraphs, my lord. Bid is in process.
What is the use of fixing on a subsequent? It should have been rejected.
Should have been rejected, my lord. But
Why?
fact
It
remains,
has
my
not
lord.
been rejected.
But
What was
fact
the use
remains,
of
my lord.
fixing it
My lord,
on a
fact remains, the
subsequent date?
the sale notice, my lord, was of 1st June.
Maybe.
My learned friend waited for 40 days, my lord, and his self-created urgency
It was
one day
very good
before.
ground for rejection of his
Yes,
application.
my lord. One day
Then he
before,
could
with the
have
approach.
challenged. He could have gone up. He could have challenged. So keeping it on a subsequent date, meaning thereby that his
My lord,
application.
what
will
I
be
have been told, my
considered.
lord, the application was moved, it was heard. The court did not consider if it's a fit case for granting any stay, my lord, had directed affidavits, my lord.
Please show me that the prayer for stay was
That's not
rejected.
there, my lord, but my lord, kindly appreciates, my lord. None of the grounds, my lord, which has been said, my lord, in the petition, my lord, goes on the sale notice, my lord. The point that has
Maybe
been taken
That was a
is
very
of
good
section
ground.
17, my lord.
That was a very good ground for rejecting everything.
Today, my lord,
That
everything
was
has
a
been.
very good ground for rejecting everything.
But today, my lord, let's understand, my lord, today, my lord, the sale has been confirmed.
Maybe.
A third party right has been created.
Maybe.
Now, my lord, all the prayers that has been made, my lord, have admittedly become infructuous because, my lord, this bank has received money, the possession is in with the purchaser who has purchased the property in the auction, my lord. Now, my lord, today, setting the clock back, my lord, in a matter where, my lord, this is a fraud account, my lord, classified as fraud. For years, they have not made any payment. A self-created urgency, a day before, my lord, when the sale is supposed to happen, they would move court, my lord. They say a petition was filed on 12th of July. 1st June was the sale notice, my lord. Nothing, my lord, can you see the merits of this case also, my lord, for the time being, my lord?
I cannot go into the merits.
The point
DRT did not go into the
No,
merits.
the
Why shall I go into the
today, my
merits?
lord, kindly seize the prayers, my lord. Kindly seize the prayers once, my lord.
Yes.
Which prayer, my learned friend, would press today, my lord? And my lord's, my lord, is covered. My lords, I am covered by my lord's lordship judgments, my lord, where this my lord, jurisdiction cannot be invoked in this kind of interlocutory order. It's an appellate provision is there, my lord.
Sir, there are counter judgments also.
My lord,
I'm conscious of those provisions.
My lord's judgments, my lord, I'm carrying, my lord.
Yes, but
Today, my lord, kindly see, my lord,
it should not be a way in dealing with the matters. 227 powers, 226, 227 cannot be taken away.
Yes,
Even
my lord, I bow down. It cannot be taken away. But my lord, kindly appreciates, my lord.
In a given
My lord,
case,
let them show any prima facie case, my lord, before the court.
In a given case, it can be invoked.
My lord, question, yes, my lord, I bow down. Court can invoke that power. But today, my lord, kindly see, do they have a prima facie case, my lord, for obtaining such a high order beyond their prayers, my lord? Kindly see, my lord, which prayer my learned friend wants to invoke. Let him press the prayer that he wants to.
Only one thing, what order can be passed now?
May I put this? I was not aware the sales certificate was issued and this has done. So let me put this again. I have to recouch my. 6th is the date fixed. hears out the application, disposes on the 6th. Because this action has heard out. I have challenged the sale procedure, my lord. 6th has been heard. But, my lord, what I will be inviting from my lords is a practice direction now. Because, my lord, this is happening in the DRT at the drop of a hat. And my lord, and I take responsibility in saying this. We move applications challenging sale a day or two prior to, my lord, the sale happening. Why, my lord? We file the put up, say 10 days in advance. The registry sees when is the date fixed for sale and gives me a date a day in advance, a day prior thereto. On that date, the bank comes up and says, see, the sale is fixed tomorrow, so let us not waste the time of the tribunal. Let us see tomorrow whether we have a bidder or not. We come back the next day, the bank comes with a bidder. Then they say, third party interests have been created, and, my lord, so we add the bidder, my lord, and we run from pillar to post.
With respect, my lord, I don't see this is a standard practice, my lord. Perhaps my lord, they may have happened in some case, my lord, but this cannot be the practice, my lord.
This is an instance. This is
My lord will kindly, my lord also appreciate.
Repeated
My lord will also appreciate, my lord. The notice was
dealt with another matter today in the morning.
I was there, my lord.
Same thing.
Yes, my lord.
Same thing. It's being adjourned on a particular day, knowing fully well that possession is going to be held, could have been rejected.
Yes, yes. I bowed down, my lord.
Keeping that pending, yes.
But my lord,
Now
kindly,
you cannot say no, he does not have
may
any
I
case.
now suggest this?
That's a very good ground for rejecting.
Yes, it should have been rejected, my lord, but there is no prime case, my lord, shown for more than 4 years. No, all the grounds taken, my lord, are the grounds of the Section 17 appeal, which has not been pressed for more than 2 years.
Lord, a sale is an extension measure under 13.4. Lord, I have to take Section 17 by grounds of Section 17. Under 13.2 NP, everything I have to take. Your lordship court held that in 2010.
So you are also out of possession.
Yes,
Now
my
the
lord, my lord friend themselves have given a letter authorizing the bank, my lord, to kindly seize, my lord. My lord friend perhaps is not instructed.
What is the letter?
My lord, they have given the possession a day after.
Possession, all right.
Voluntarily.
Possession you have taken under Section 14. Do that.
But that was after sale. This possession is not under 14. After sale, day after the sale. Yes, yes. Kindly seize, my lord, this.
Probably not, my lord, probably not.
Yes, yes.
My lord, kindly seize, my lord.
এটা দেখুন একবার দেখুন তা সেল সার্টিফিকেট দেখুন
My lord, kindly seize the sale notice. I guess my learned friend has not been properly instructed. Page 290.
my lord, kindly also seize this, my lord. It also.
Physical possession of the property taken by the bank on 29 December to be 2025. My lord, kindly seize.
No, from where are you?
This is page number 292.
So, Mr. Bordhan, have you seen this letter which is handed over?
Kindly see this next page.
Thereby authorized Mr. Shomit Das to
We have to remove because when they have sold it to someone else, there has to be authority given to us. It must be that they have called upon us to remove our goods, my lord.
My lord, lot had happened on that day. They had broken the main door, my lord. Physically abused the persons, my lord. Those things are there. I'm not troubling my lord with that. Now, my lord,
that is neither here nor there, but
therefore, my lord, did not say that.
An approach of the tribunal. This should not have been the approach of the tribunal. Ashun.
I'm so grateful.
Yes. Yes. 14 yes.
Same for the petitioner decree holder, my lord.
Yes.
There is a matter of eviction under ground of 2G.
What are you challenging? What order?
Challenging the.
What do you want? To dispose of the miscase. What is the miscase arising out of? Which proceeding? Section 47.
Yes.
This application under Article 20.
I'm opposing this application.
You are opposing? Yes.
But this is a subject matter of challenge of order of the learned Chief Judge City Civil Court. I have filed an application under section 10 for transferring the execution case to bench number 12 where the connecting title suit is pending.
For transfer?
For transfer from 7th bench to 12th bench because the suit is pending on the self-same cause of action, self-same property, or the right title interest is in the challenge, and the degree holder herein is a substituted in 2020-25. A suit was filed in 2020. At that point of time, he was not claiming his right title interest. He pending appeal before the division bench substituted. The only one point is this: when the learned chief judge disposed of the miscellaneous application with an observation, the right title interest will be decided in as per 101 of order 22-21. That is the observation in page number. Internal page number.
This
3.
Execution case is arising out of which decree?
Arising out of degree. Initially, the landlord filed a suit in the 7th bench that was dismissed.
For eviction?
Eviction. That dismissal order was challenged by the landlord, that is division bench. That was decreed in 2025, December 2025. And in the meantime, the company, Nico Corporation, went into liquidation and property was sold. That process was under challenge in 2020. Auction sale, cancellation of deed, right title has not been passed on. The building is unauthorized. In the meantime, corporation demolition order passed about 55,000 square feet out of 60,000 square feet. That is the proposed auction. That means from the very gamut of all this order, it is clear the building cannot be put in public auction. In spite of that, the degree was passed. When I brought to the notice with the Honorable Division Bench by way of a review, that degree has not been disturbed, but the right title interest is always open. That is also admitted by the learned chief judge. But the right title interest, deciding the right title interest, the two different courts, bench 7 and bench 12, on the same very property between the same very parties cannot be continued because there is a possibility of multiplicity of proceedings. So it should be clubbed in one bench.
When you have filed the suit?
Suit filed 2020.
No, after the execution case has been filed or
no.
that?
Execution filed in 2026. Or I have filed the suit 2020, 6 years ago. Even the appeal was pending. When the suit was filed, the appeal was pending. But landlord, tenant, landlord. Case is same. He has substituted. The point is this: if the two courts proceed with the determination of right title interest on the same very property, that would be a conflicting of decision. So it should be heard by the same very bench, nothing else.
Mr. Mitro, what is the difficulty if both the proceedings are transferred
The
to the
suit
same
he's
court?
talking about, I'm not a party in that suit. So, and that suit, for that he has already filed Order 21, Rule 29, because there are two proceedings, which has been dismissed. Or she kindly takes a
That
look
has
at
not been challenged. That
that has
order
not
has
been challenged.
I'm,
And
I'm telling
number two, the decree was passed by the appellate court, from which they go to the Supreme Court dismisses. They come up in review. In the review, they take the same points that the suit's pending, and the division bench has recent as 3-4 days back given a finding on this. Lordship kindly comes to the division bench judgment. Firstly, paragraph 10. 10,
paragraph 10.
Paragraph 10. Thirdly, this is page 4. Thirdly,
there is WPLRT. Why WPLRT?
Also, WPLRT had filed. So, because from a 36th order, so by the BR, the LRT had also reviewed paragraph 10. Thirdly,
36 means 36 of
DPR.
of the Premises Tenancy
Premises
Act,
Tenancy
there
Act.
was an order for repairs. So from that LRT,
that they went before the
LRT. Now, Lordship kindly come to paragraph 10.
Yes.
Thirdly, it is argued that that there are two suits pending at present at the behest of the review applicant, challenging the sale of the suit property in liquidation. And paragraph 12, in the teeth of the pendency of the said matters, it is argued that the title of the opposite parties itself is clouded. As such, this court committed error apparent on the face of the record in granting an eviction. And the finding apropos, this is paragraph 38.
38.
Page 13. Page 1-3. Second last page. Insofar as the pendency of other civil suits and or demolition order in respect of the suit building are concerned, those cannot be a relevant considering in respect of a decree for eviction. Because, my lord, two things. Because in both the suits, I'm not a party. One suit, now after the decree, after the eviction decree was passed, where execution put in, they made application for addition of party, which are pending, to make
addition of party
my client in those suits where I'm not a party. So they will make me a party in that suit someday, and then Order 21, Rule 29 will be once again filed maybe. And now so far the suits are concerned. Kindly see the suit. What is the he has not annexed the plane.
All right, come back at 2 p.m.
2 p.m. তোমরা করতে পারো, আমি আটকাবো। Can it be at 3 o'clock? Well, I have a rare chance to go and do a bail matter in the other building for the division. Well, if I can come back at 3 o'clock.
দেখি এই বিকেলবেলা কিছু আছে 4টে না হ্যাঁ
Grateful to my, I'm very grateful.
4 p.m. Can finish off that matter in the
Yes,
weekend.
kindly wish me good luck for that because I do not know that branch at all. I'm doing the civil matter, that's why I'm brief.
Thank you.
problem that I am facing personally. The item number 48, my lord, after today, my lord, I'll be a little uncertain for a few days. See, if it comments to your lordship, my lordship, can I take it up, my lord, maybe on the 5th or even today, my lord, if it comments to your lordship, my lord, because there is no caveat.
48.
48. Whenever your lordship pleases, my lord, if it possible, then I can do it today, my lord.
Will not be available from when?
My lord, basically from now, but tomorrow I will definitely not be available, my lord. Thereafter on 5th, I should be able to come on and off.
5th will be available.
5th I will be. If your lordship can fix it at 10:30 on 5th, my lord, then I can come and then go back.
Who is appearing for port trust?
Nobody, there's no caveat. So there will be a direction to serve.
All right, let me see how far I can reach today. If you
Lord,
are,
Mr. Kormokar is here, he'll remind your lordship, Lord, at the end of the day.
all right. Yes. So, call the list. Yes.
Section, I am for the BNC Lordship along with Mr. Kankhani. He is in online.
Yes.
Service.
You are for the?
This was my application before the tribunal. We obtained.
You are for the complainant?
Not for the complainant.
My lord, I am for the
complainant. Both sides, both group of this within the same family. My lord, there are the unauthorized constructions allegation from against each other. My lord, two sets of writ petition moved before this court, which are pending. There were the order for the demolition also. Thereafter, my lord, in all these matters, all the co-sharers were not the party. One of the co-sharer on the date of the application, when it was they came for the demolition, she came to know there were demolition proceeding which was going. At behest of that co-sharer, an application for stay was filed before the learned tribunal, and the learned tribunal was pleased to stay the demolition proceeding by condoning 338 days.
No. No.
Days
Interim order was passed. Subsequently, date was fixed for taking up Section 5 application. Initially, interim order was passed. On that day, my lord, Section 5 was not taken in. My lord, kindly
you are for the petitioner?
I am for the petitioner. My lord.
Yes.
My lord, kindly takes up the first revisional application. My lord.
But the complainant?
I am the complainant. I subsequently made an application for addition of party that was allowed, and thereafter I was added a party on 15th of January.
The appeal before the tribunal.
In the appeal before the tribunal.
Yes.
Now, my lord, in the first order which was passed, that is, my lord, item number 16.
Item number
16, my lord.
How many revisional?
Two revisional, 16 and 17.
Oh, 16 and 17.
Yes. 420. Yes, my lord, the order impugned.
Both the matters you are the petitioner.
I am the petitioner.
Yes.
After page 52.
Yes.
My lord, the operative part of the order is kindly comes to the page number 3 of the order, my lord. My lord, kindly see the submission of the Bidhannagar Municipal Court. On the other hand, my lord has got page 3, my lord, internal page 3 of the order.
Yes.
On the other hand, learned advocate for the respondent number 1 to 3 submitted on instruction there is no schedule in the month of January 2026 for demolition of the impugned property. So, my lord, there was no urgency at that point of time. Considered from the submissions of the learned advocate and averments of the instant application for stay, it appears that the appellant is a co-sharer of the impugned property mentioned in item number 3 of the impugned recent order dated 28/1/2025. It also appears that the appellant was not issued notice to contest the demolition proceeding. Considering the directions content in Honorable Court's decision referred to by the learned advocate for the appellant, and in view of the submissions made before us, we think for the interest of justice an order of interim protection is necessary, otherwise the appeal will become infructuous. Accordingly, respondent number 1 to 3 are directed not to take any coercive measure in respect of the impugned property till next date.
Now, my lord, when is the next date fixed? 15/1/2026 for receiving demolition case record, application for limitation hearing, application for addition of party, and hearing stay application. So, my lord, when the BMC submitted on their own that there is no urgency in the matter, on the same day, we take that addition of party has been announced. Because sometimes that information and security application was challenging.
Where is the order of demolition?
Page 47.
Many buildings have been erected to be demolished by virtue of a same order.
So you are, Mr. Chatterjee, you are Tanuja Bibi.
I am Batul. Tanuja Bibi was not.
The same building where a notice protection was given. Prior to that, at least twice the demolition.
But at the same time, Tanuja Bibi did not receive the notice. It is also an admit fact. But she was not served with any of the notices. You are aware. What should have served?
You are also a questioner.
No. No. In respect of a separate DAG.
Oh, not separate DAG. That second.
But we are on the section 5. Kindly takes up the section 5 application.
The land mine.
Kindly takes up the section 5 application. Page 37 is the.
So your building has been directed to be demolished.
Yes.
Protected by the Landed Tribunal. There was an order of demolition in respect of my building. The Honorable Tribunal has.
Your building is which building? One,
not over here. Not over here. Not of any of these buildings. In a separate proceeding. Well, it kindly takes up the page 37, their application for under section 5. And only one respectful submission. In respect of this building, Mr. Chatterjee has moved an appeal before the Honorable Division Bench, and the Honorable Division Bench has categorically directed demolition within 1 month.
No, which
in respect of the same building, and Mr. Chatterjee, with greatest of respect, Mr. Chatterjee moved before the tribunal without citing this order. Kindly have a look.
Well, he preferred before the division bench against which order?
There was an initial demolition order which I have showed your lordship, I preferred a writ petition seeking implementation of the said demolition order. Mr. Chatterjee's client.
Where is that demolition order?
Same demolition order, this one, which I showed your lordship. May I finish, my lord? Mr. Chatterjee will.
Particular order was challenged by.
Mr. Chatterjee, I will. This is the order of demolition.
Yes, my lord.
So now,
my lord, I have shown your lordship the order ordered at page 47, passed by the commissioner. That is 28/1/2025.
Yes, yes.
Now, my lord, I filed a writ petition challenging seek implementation of the demolition order before the honorable coordinate bench. Challenging that order, Mr. Chatterjee appeared.
So that was allowed.
That was partially allowed, and it was directed for demolition. That order was taken up in appeal before the honorable division bench, and the honorable division bench categorically dismissed the appeal and directed the BMC to execute the demolition order within a period of 1 month. That order was passed on 18/7/25. Kindly see the order impugned. It was on 23/12/2025, my lord. It was, although not by the same party, but with greatest of respect by the same learned advocate, my lord. With my lord, judicial decorum says, Mr. Chatterjee, being a senior member, would have indicated the same before the learned tribunal.
This was completely with respect of Tanuja Bibi, my lord. Admittedly, Tanuja Bibi's building was not considered within this particular order.
My lord, it was the same demolition.
Let my learned friend show that Tanuja Bibi was served. There was any order again passed.
That is for the BMC to show.
So my learned friend cannot take the benefit of that, man. Admittedly, there are many buildings within a particular land, and that's why I started with it. Well, this particular demolition order was passed against several buildings.
January 2025.
Yes, paragraph 5, the same order.
So 28th of January 2025 was the subject matter of challenge before the single bench.
Yes.
Now,
now, my lord, kindly see paragraph 5 of the division bench.
Single bench directed demolition of the to be effected.
Yes, my lord. Now, my lord, kindly takes up paragraph 5. The challenge in the instant appeal is to an order dated 6th May 2025 passed by a single bench of this court. The single bench found that the Commissioner of Bidhannagar Municipal Corporation passed an order under section.
Which paragraph you have?
Paragraph 5. Paragraph 5 of the order. Second page, my lord.
Yes, yes, yes.
The challenge in the instant appeal is to an order dated 6th May 2025 passed by a single bench of this court. The single bench found that the Commissioner of Bidhannagar Municipal Corporation passed an order under section 266 of the West Bengal Municipal Act dated 28th January 2025. My lord, I have shown your lordship the order 28th January. Rejecting the representation of the appellants and directing demolition of unauthorized construction effected by the appellants as found in the inspection report. The single bench further noted that a due opportunity was given to the appellants to carry out self-demolition, which was not done. Therefore, the Bidhannagar Municipal Corporation was duty-bound to comply with the demolition and collect charges thereof from the appellants. Senior Counsel for the appellants has placed a notification of the Department of Urban Development Municipal Affairs dated 6th May 2025, which has stated to apply to all municipalities in the state. Kindly, my lord, skips over the further thing, and my lord, kindly comes to the concluding part. My lord, kindly comes to page 4.
Yes.
In view of the aforesaid observations, sorry, my lord, I'll read paragraph 12 also. An appeal is stated to have been preferred under section 266 of the Municipal Building Tribunal against the order dated 20th January 2025. Admittedly, the act requires a person aggrieved by an order of the commissioner to prefer such appeal before the building tribunal within 30 days thereafter. The purported appeal dated 11th June 2025 against the order dated 20th January 2025 has been filed after the impugned order was passed and to enable the appellants to delay the implementation of the order of the commissioner and to frustrate the order of the single bench. Such conduct cannot be permitted. The municipal commissioner shall take an immediate steps to ensure demolition of all unauthorized construction that a subject matter of the order dated 20th January 2025 passed by the commissioner, Bidhannagar Municipal Corporation, positively within a period of 1 month. And the appeal was disposed of. Now, my lord, when they failed to obtain an order by this appellant, a fence sitter was there by whom another appeal was preferred before under section 266(1), suppressing this order. And Honorable Division Bench categorically records that the pendency of the appeal was only to frustrate the implementation of the demolition order. Without even taking into consideration all these facts, my lord, the learned tribunal proceeded to pass an interim order without even taking into consideration the 313 days delay and the explanation given in the section 5 application, my lord. And this order was completely suppressed before the learned tribunal. And this is same order, my lord, a printout. And my lord kindly now takes up the section 5 application at page 37. My lord has got page 37.
Yes.
But page 37, 38, 39. Kindly comes to paragraph 6. Your petitioner states that the petitioner came to know about such order when the said authority of the Bidhannagar Municipal Corporation on 19/11/2025 came to the said premises for comply the said order to conduct the demolition proceeding. Your petitioner states that thereafter, without wasting time, applied for certified copy and obtained the certified copy of the order on 28/11/2025. That after obtaining the certified copy of the order, the petitioner herein, without wasting the time, filed the instant appeal before this learned court. When they went for demolition, at that point of time, they have come to law this. That thing itself, where it was mentioned before the honorable division, the demolition is going on today.
Well, this is admitted fact. There was no copy served to Mujar.
Copy served to Mr. Chatterjee. Your building is which building?
Third one,
building is
third building.
Third building.
Third building.
WB is a co-sharer in respect of that property. Property is undivided.
Who are the other co-sharers? So building number 3, you are a co-sharer.
Well, yes, sir.
Who are the other co-sharers?
Well, other co-sharers might have been Asghar Ali Piada.
Asghar Ali Piada is the complainant, my lord. Is the complainant.
Well, she is one of the sister of Asghar Ali Piada.
One of the sister of
Asghar Ali Piada.
Asghar Ali is the complainant.
Well, there are two sets, two groups, co-sharers.
No,
One
here,
fighting-
Mr. Chatterjee, please kindly come to the order passed by the commissioner. With regard to the third building, you are concerned with the third building. Third building, living persons is Bashiruddin Piada and Sabiruddin Piada.
That's a wrong recording, wrong find. Bashiruddin,
So you are the co-sharer. What document you have to show that the building is an authorized one? Please show me.
Well, today I'm not in a position to show. Well, if you watch it once, I can bring
Tomorrow,
whatever.
please show me the sanction plan of that building.
Well, one thing, kindly come to this building number 3, their order also.
Yes, building number 3, yes.
So Lordship, kindly come to status 3-story building.
Yes.
Kindly come to old building before 20 years. My lord,
Yes.
kindly take 20 years.
Yes.
And this one based on sometimes.
Yes, 20 years takes us to
2005.
2005. 2005.
Yes, so
My
it's
lord,
immune
they were-
from demolition, Mr. Chatterjee. Is it immune from demolition?
There was protection for under the act. My lord. Prior to
Show me the protection under the act.
that the old building structures. which
Please
were
show me under protection under the act. Under the 1980 Act.
No, my lord, the West Bengal Municipal Act, there is no
What happened? Earlier it was under the West Bengal Municipal Act, and thereafter, and it was within the Panchayat area. That is the problem.
When it was within the Panchayat area.
Well,
When it was within the Panchayat area.
it was in 70s. And till now, till today, that area is within the Panchayat area.
No. Rajarat
Then
Gopalpur
became
Municipal Rajarat Gopalpur Municipality was formed in 1991.
Rajarat Gopalpur Municipality was formed.
in
So it's under
1991.
West Bengal Municipal Act. And
Yes.
now, my lord, there is a this another act, my lord, that is
West Bengal Municipal Corporation Act.
You are staying there in that property?
No.
Who are staying there? Can you furnish the names who are staying there?
Well, I'll take the instruction on that.
I see where page 20 plots. Can you also page 20? Wife of President Government,
You have received the copy of this writ petition? No, this copy of the civil division application you have received.
Yes.
You have served by post. You have received at this address. This shows you are not there at the premises where you are saying. You are not residing there.
I have received that.
You are not residing there. You are not residing there. You have been set up.
My lord, I have instruction that I reside. Well, there are two things, my lord. First of all, my lord, the dispute is arising out of the branch of the inspector of which was second appeal state.
That I am not concerned about the fight it out there. I am only on the second appeal. You get a stay of this.
No.
Nothing. Second appeal, I am not on that. It's a demolition proceedings arising out of that. Some co-sharers going there, some co-sharers coming here.
Order itself, Lord, you kindly examine this order once. One order directing the demolition of many buildings.
You are not there. How could it be solved, Mr. Chatterjee? Could not have been solved. It could not have been solved. Could not have been solved. You are not there. How could you be solved? How you came to know?
From the other people.
Yes. Who are the other papers? Who are the other people? Have you?
I'll ascertain my lord from
Section 5 application is vague. You have not stated anything. That's vague.
But admittedly, there was.
You have said that when they came to the possession, you are not in possession, you are not in deciding. That could not have been your source of knowledge.
That my source of knowledge is that I came to know that they came for the demolition.
How did you come to know? Who has informed you?
That I have to take instruction.
Well, they cannot improve the Section 5 pleadings. Well,
Section 5. Section 5, I am dismissing that Section 5, rejecting. That order cannot be in this way. Section 5 cannot be allowed.
Whether I fall within that statement or not, that has to be ascertained by the
Let the tribunal again reascertain. Let the tribunal again reascertain. Without condoning the delay of 313 days, interim order has been passed. Mr. Chatterjee, this cannot be supported.
The only thing is that why I'm
Yes, you fight it out. Let them file the written objection. Let it be decided. I'm not against that, but this should be vacated here and now.
But kindly grant me an opportunity to come back and
For what? Go there.
but since your lordship is vacating the interim order.
Has to be. Could not have been interim order could not have been passed prior to condoning the delay. So there is no appeal in the eye of law. How could an interim order be passed?
Then it will be directly for the demolition. That will.
Let them demolish.
In that case, lordship
Wanted to steal a march. Mr. Chatterjee, your clients wanted to, I'm not meaning you, your clients wanted to steal a march. They were well aware, some coming, there, some.
The only thing is that it's a problem started with the corporation itself.
Mr. Chatterjee, the most difficult thing is that an appeal filed, I think 1 or 2 months with delay, the Honorable Division Bench did not even care to look into it, saying no.
Even lordship kindly come take the order once. Lordship 47 once, my section. The nature of the order.
Yes.
Instant proceeding drawn up for the compliance of the order dated Honorable High Court such as.
But Mr. Chatterjee, even in spite of that, taking note of the fact that an appeal has been preferred only after 2 months, the Honorable Division Bench said nothing doing. Let it be carried out.
But at the same time, the Honorable Supreme Court says
They have to be given an opportunity because the tribunal ought to have been apprised of the Division Bench order. Otherwise, nobody knows. At one point of time, the tribunal may be hauled up. saying that
My lord, this
division
was
bench has
confronted
directed
by-
demolitions.
This was confronted by them. They were present.
Let them point out this now before the tribunal.
Point
Let
out,
it
but
be,
your lordship,
let it be heard afresh.
Do not vacate
Let it
the
be
interim
6th
order.
of August.
Till 6th of order, the corporation should not do anything unless the tribunal hears out. But the only thing is that is another problem.
With regard to building number 3.
Building number 3, rest I am not concerned.
Yes, and interim order will be, you are concerned only with building number 3. Where have you stated in the stay application with regard to building number 3, that is your interest?
But may come back.
That is also vague. Nothing has been stated, Mr. Chatterjee. I record your submission. You are concerned only with regard to building number 3. So rest of the building, no stay. Stay is past blanket overall. Where is that? All right. So building number 3. So
Well, Lord, kindly also consider their conduct. They are also facing the same demolition order, and that is not heard by the High Court. That's why they are taking the privilege. But
no, where is that?
coordinate them. One matter is
They have challenged.
We have challenged. We made a complaint against them that demolished those structures which are completely unauthorized, and that writ petition is pending. Now, somehow, my lord, my learned friend had persuaded the Honorable Justice to pass the order against us. That matter was heard, but our matter was not heard. It is still there. Now, there is another thing. One is we are not a party made there, my lord. That is another problem. That is the conduct.
That is, you take steps
That's
in
the
that.
conduct. Even
You take steps in that
my lord,
proceedings.
Mr. Bhattacharjee was appearing, reading my learned friend, Mr. Vishnu Bhattacharjee. We had a talk that we will come up, we will resolve this problem. Matter was before the Honorable Justice Gaurang Kal. So they agreed on that. We have discussed it. But again, sometimes this matters comes up and not the petition. That is the problem. Once for all, this matter can be solved if your lordship take up all these things together. There are many structures, lordship knows, property, many buildings.
Dispute resolution by way of keeping unauthorized constructions cannot be the solution.
Everything unauthorized. In that,
So everything has to be demolished.
Has to
Let everything be demolished. That's the only solution.
So that's the only solution. In that case, lordship, I will also give the number of the writ petition which
I cannot take up that writ
So,
petition.
lordship, just record it. It is because that's if that point I may have to take in some point of the time that will become very important because your lordship is also required to lordship evaluate the conduct of the person who has come before the court, whether he has come with a clean hand or not. Because revisionist has come before the court, whether he has come with a clean hand, what are their interests which are involved.
Now I'm looking at this order, Mr. Chatterjee. Two things. One is when an appeal has been filed with a huge delay, without condoning the delay, there is no appeal in the eye of law. No interim protection could have been granted.
I understand, Major. I understand the problem.
So
the only problem is that lordship kindly do not vacate that interim order. Let us go back and argue this.
But unless the other matter, what has been done? Hearing of the stay application on 15th of January. That could not have been done, Mr. Chatterjee. This order has to be vacated. Condonation could not have been allowed without giving them an opportunity to object.
Let the tribunal decide it. Till then, lordship kindly protect.
It will be decided by the tribunal on the 5th, my lord.
Yes, go. Rest of the building, let it be demolished.
But in fact, the interim order is only in respect of building number 3. That is recorded in the order, my lord.
Yes.
Second argument.
দুটো Yes.
My lord, praying for early disposal.
Early disposal of what?
Civil suit already pending. Arambagh.
What is the stage of the suit?
TS 50, case number TS 51, 2021.
What is the stage of the suit? For taking step. You have not taken steps. You have not taken steps. What is the stage of the suit?
My lord, praying for short passover.
This application under Article 227 of the Constitution of India is a
Your Lordship, this is my application, which I'm praying for expeditious disposal of a title appeal. But Your Lordship, there's something that
Who are you?
Your Lordship, I'm the plaintiff in the suit. The suit was dismissed again.
Suit was dismissed.
Dismissed suit for eviction and recovery of possession. Your Lordship, there is something which is why Your Lordship, I will pray before Your Lordship not to pass the usual order of expeditious disposal. Your Lordship, when I was sitting here, I got the opportunity to actually 33 orders. Your Lordship, out of those 33, Your Lordship, 22 orders, there is a resolution by the local bar and the PO is transferred. On 8 occasions, the respondent, Your Lordship, who is the defendant in the suit, takes adjournment. 3 occasions, Your Lordship, I am at fault, I don't take steps. Your Lordship, my appeal was filed on 4th of December 2019. There was an accompanying Section 5 application, as a result of which it was admitted on 13th of January 2020. Your
Section
Lordship,
5 allowed.
Section 5 has been allowed. Your Lordship, because immediately after, short delay of around 2
So
weeks.
Section 5 allowed.
Your Lordship,
Now-
today the suit is for final hearing for the last.
Appeal is for final hearing.
I beg your pardon, Your Lordship. Appeal is for final hearing for the last 5 years. Your Lordship, I am praying, Your Lordship, kindly fixes a timeline, Your Lordship, of, I was going to say 4 months, but 6 months, Your Lordship, will kindly appreciate. Your Lordship, I can take Your Lordship through the orders, in fact. Lordship will kindly take, the last 3 orders, respondent is not appearing. Lordship takes any order in between, there is a resolution by the local bar.
What can be done, Mr. Chakraborty?
Why, Your Lordship, I'm not saying this is, Lordship, the apathies of the litigant. Lordship, in fact, at our stage, we also feel it, because on Saturdays, when from our houses we go all the way to these district courts and there is a local bar resolution, nothing can be done. Your Lordship will kindly pass a directive 6 months, which is why I'm playing for 6 months. Everything is on record.
You will take resolutions, Mr. Chakraborty, there, and you will ask now the judicial officers to expedite.
In fact, for judicial officers also, Your Lordship, it's very easy for us to go and cite 10 judgments through the law. Ultimately, Your Lordship, given these practical difficulties, they have to render justice. But Your Lordship, let the litigant not be apathized for that. I am only bringing to Your Lordship kind consideration and benevolence.
What was the suit for?
Your Lordship, suit for eviction and recovery of possession. Your Lordship, the
Reasonable requirement suit, default, dismissed. Why?
that, Your Lordship.
Not have any merit in the suit, it appears.
If that was the case, the respondent would not have taken to take 8 adjournments on repeated occasions. The Lordship takes the last 3 orders. So I am praying for not the usual order of
These.
declaration of formal injunction. By there have been twice this court has directed the trial court to finish off the suit by 2023. Thereafter, this year, March 2026, the matter is still pending in a preliminary hearing stage matter. I'm only seeking for mandatory direction upon the line of the trial court. My lord, can we come to page number 34, my lord? The order starts page number.
So it's further evidence of PW1.
Yes, my lord.
What is the application for?
The application is for, my lord, it was directed upon the plaintiffs to provide documents and submit documents and a books of account which will be presented.
There were 2 applications.
Yes.
One is dated 23rd of March and other is dated 17th of April.
Both the application with the March or application of the plaintiff, my lord, both the application are defendant. I'm judgment.
You are the plaintiff.
I'm the defendant, my lord. I'm the author who is not receiving his royalties. I have terminated the agreement with the plaintiff. Plaintiff has challenged that, asking for a permanent injunction and declaration, my lord. Since 2022, my lord, this is going on. My lord, please kindly come to page number 34. Challenging an interim order, the defendant came before the honorable court. So the order starts from page 32 at 34, my lord.
directed by this or division bench of honorable court that the suit is charged and determined by 15th September 2023. Thereafter, my lord, again, if my lord kindly comes to page 56, my lord. And the order dated 6 January, the my lord, the operating portion is at page 58, paragraph 11. My lord, got it? Paragraph 11. Simultaneously, we express hope and trust that the learned trial judge shall dispose of the suit itself.
This application under Article 220. Said keeping in mind those directions. I cannot extend that.
My lord, under 2227, my lord can pass
No,
a
no, no,
mandatory direction upon the.
That is why I have said keeping in mind. Division bench has directed, I cannot modify that.
But the
Yes.
time limit has elapsed, my lord. That is the reason why we are before your lordship.
That is why I have said keeping in mind.
Grateful.
Those, that will be better because the division bench orders are there. Yes, next.
I propose the petitioner, my lord. The PMT in respect of an application for preemption. My lord, short
PMT.
Short deposit. I have filed an application under Order 7, Rule 11 that was refused. My lord, application was filed in the month of December 2024. Subsequently, immediately preceding to the date of rejection, that deposit was made.
Immediately
preceding to the date of rejection, date of hearing of the application, my application. On my lord, 4th of April, my lord deposited, 10th of April, my lord, this application was heard.
It's a non-notified course error.
Non-notified course error.
So 97, 1 year is the period of limitation. See, 1 year is the period of limitation. The time was there to deposit the short consideration within 1 year. That has been done.
Okay, so my lord, if I, my lord, rely upon my lord Abdul Mutin Mollik, my lord,
Please use the microphone.
my lord, if I get to rely upon Abdul Mutin Mollik, my lord, at the time of my lord filing this application,
The law is within the period of limitation.
within the
Yes, he has done that. Within 1 year is the limitation. Non-notified course error. That's the decision.
and my
So
lord,
period of limitation, it has been done within the period of limitation.
there are other grounds that was taken at the time of hearing.
What grounds?
With regard to my lord, my lord,
That will be decided in the evidence, not Order 7, Rule 11. That has to be proved. Ashwin. Yes. Non-appeals. Service is not complete. What service? Caveat is there. What is there? Nothing is there in these. You can move without the opposite party. Yes. Who is leading you? Where is he? Ask him to come. Pass over. Ask him to come. Yes. Pass over. Next. What is the stage of the suit? What? What happened to that? So it has been fixed on 21st of August 2026. Order 1 Rule 10. Order 1 Rule 10 hearing. This application under Article 2.
There was a cabinet services for
Service is complete. Yes.
and the achieved for I not I
Yes.
by an order of the London Trial Court allowing an application under section 121 kindly the issued order of 30 June 2026.
Police help for what?
The parent order of injunction for the plaintiff, I am the defendant, on number 1, 2, and 3. The plaintiff is a trustee and the pro forma defendant is a son of a deceased trustee awaiting induction. Now, I am, my lord, tenant in the suit premises. Plaintiff case proceeds on the allegation that I trespassed into another apartment.
Please give me a minute.
এবার ঠিক আছে।
You have entered appearance in the suit now.
Lordship, entered appearance.
What happened to the injunction application?
Lordship, injunction application is still pending for final
You have
disposal.
filed your written objection.
Yes, Lordship, absolutely.
When it is fixed for hearing?
Lordship, what is the
My lord,
next?
I am for the, my lord, in this matter, my lord, I am for the plaintiff, my lord, I am the caveator, my lord. My lord, on the last occasion, my lord, they have appeared in the suit and it took time to file written statement. They have not yet filed the objection to the injunction application. They sought for adjournment, my lord. Last date order.
Lordship, on the last date, there was no direction for filing W because in the prior to there being any direction, they filed a 151 application, which I have opposed. My grievance is with the learned trial court's order in the 151, Lordship, and my grievance goes to the root of the matter.
Where is the order passed under? Where is the order of ad interim order of injunction?
Lordship, 22nd May,
My
that
lord,
is
it
at
is
page
appearing at page number
160.
160, my lord. Page 160, my lord.
I will demonstrate, Lordship, 39 3AB not complied with. And that was the
My
point
lord,
that I took in the 151. And
my
most
lord, he
respectfully,
being
the
the
learned trial
tenant
court
of
does not
under
pay.
the,
It is my application. My learned friend will kindly let me move it.
When you came to know of this order of injunction?
Lordship, it was served upon me sometime. Service. Lordship, kindly give me one moment.
my lord, it was passed on 22nd May and served upon the defendant on 23rd May. My lord, the affidavit of service they have annexed at page 198 onwards, my lord. And my lord will find it from 202.
Lordship, kindly sees.
My lord,
Shortly
booked on
after
22nd
22nd of
and
May.
delivered on 23rd.
Shortly after 22nd of May, Lordship. And I enter appearance on 24th of July.
No, my
Thereafter,
lord.
Lordship, they come up. The records will speak for themselves, Lordship. They come up with a police help application. In my written objection, I say 39 3AB, no compliance. Their own affidavit of service will demonstrate that. Kindly seize, Lordship, their affidavit of service, which I have annexed at page 195 onwards. Kindly takes that, my lord. Lordship has found it.
What is the next date fixed in the suit?
27th November, I'm told.
27th of November.
Yes. My most respectful submission in the 151
My lord,
application
there is a
was that the
pending
injunction
suit.
cannot survive. Their own
My lord,
affidavit
there
of
is a
service shows
pending
no
suit
service of
among the
plaint.
trustees. My lord, just once, my lord, kindly see the order annexed at page number 144. My lord, kindly see. There was a pending, there is an ad interim order.
And kindly sees the impugned order, Lordship. Most respectfully, there is no passing mention of my submissions or why the learned trial court holds that my submissions are not to be considered.
My lord, kindly just
Why
once, my
police
lord,
help
see
is
the
being
order
granted, Lordship.
appearing at page number 142,
So
my
my
lord.
learned friend will
My lord,
kindly
the
let
pro
me move
forma
my
defendant,
application.
pro forma defendant is
And admittedly, the plaintiff is not in possession of the suit premises. It is admittedly in the pro forma defendant. No prayer for recovery of possession made in the plaint.
Yes, my lord. Now, my lord, kindly
not
see.
serve the plaint. That is apparent
My
from
lord,
their own
kindly
affidavit of
see
service.
paragraph, page number 144, last 3 lines, my lord. My lord, just for once, 140. Trustees are required to act jointly. Then the last third line, the trust properties cannot be alienated and or encumbered without the leave of the court. And then, my lord, see the admission of the petitioner defendant, my
where
lord.
is the application under 151?
151 application is lordship at page 162 onwards.
162.
Yes, my lord. The relevant pleadings will be at 164 and 172. And the complaint on which they based the application is at 170. Kindly see, lordship. Allegation that I had trespassed in the afternoon, and the complaint is posted to the relevant police station 24 minutes after the alleged incident.
My lord, it was written afternoon, and he has calculated the time from 12 noon exactly.
Less than 24.
Now, my lord, kindly see the number 175, their admission that they have trespassed and they are claiming.
It's an old building. It's a rented building. And I am a tenant, lawful tenant under the plaintiff, under the trust.
What is the suit for? What is the suit for?
My lord, the suit for declaration and injunction, my lord.
Declaration injunction. Where
My lord,
admitted
Where is the plaint? Where is the plaint?
plaint is at page 21 onwards. Kindly sees the press. Page 29 onwards.
My lord, for once, my lord, kindly take up the objection filed by.
Please give me a minute.
Sure.
Yes, you are a tenant in respect of which flat?
A flat on the ground floor.
What is the number of the flat?
That's right.
Block
B.
B for Bengal. So you do not have any right with regard to flat number D.
Not
D.
Absolutely.
So the suit property is with regard to the flat number D
Yes.
of block E.
Yes.
So if you do not have, how are you affected with this order?
By it at all, Lordship, 7, except something has been pleaded on affidavit which is incorrect, and therefore it goes to the root of the injunction passed. And Lordship,
No, that is neither here nor there. But if you cannot take possession with regard to flat number D. That's the only. Maybe you are not. It's not in your possession. So pro forma defendant, whether their pro forma defendant is aggrieved or not, that's neither here nor there. Yes. So if this order of injunction is against flat number D, so you are not claiming any right in respect of flat number D. So how are you affected by this order of?
My lord, they are claiming their right, my lord. My lord, they are
Sir,
objection.
if you make a running comment
My
with
lord, pardon, my lord.
virtual,
My lord, pardon, my lord, pardon, my lord. My lord, pardon, my lord.
It's very difficult. I'm not accustomed to hearing two hearings from two advocates.
No,
at the
my
same
lord,
point of
pardon.
time.
Pardon.
Yes.
my lord, my specific case in the written objection was that the only times that I have entered into the apartment in question was on the specific authority of the pro forma defendant, who is admittedly an undisputed possession of the apartment. Having said that, the application under 151 proceeds entirely on a false basis. The allegation made of alleged trespass did not in fact occur. I have pleaded that in my written objection. The point I am on today, my lord, is at the time when the learned trial court passed the parent order of injunction, naturally necessary directions for compliance of Order 39 Rule 3A and B were passed. Those have not been complied with.
You are not affected by that order of injunction
Now,
because you are not in
will-
possession of
they
plot number.
No, the
D.
difficulty is, Lordship, Muchipara OS has been directed to ensure that the injunction is
Yes.
now
So you
they
are not affected.
forcing me. They are coming over and saying, have you gone? Have you been there? Do not go. I cannot be today subjected to humiliation or harassment by the police authorities at the instance of a plaintiff who has not complied with the law, my lord. And it is their own affidavit of service that will show.
For that, you take steps. I direct the trial court to file your written objection. The injunction application will be decided.
Lordship kindly
but only
expedites the hearing of the injunction
yes,
application.
injunction
I will file my
application
written
will be
objection in the
expedited.
May I, Lordship, only point out one thing? Since that is the case I made out in my written objection, kindly takes page 195 once, Lordship.
195, yes.
195, Lordship. That is the plaintiff's own affidavit of service, averring that 3A rather, has been complied with. Lordship has the affidavit of service?
Yes.
Yes, Lordship, the relevant averment has been made at paragraph 4, page 196. Kindly
Yes,
see.
yes.
Yes. Now, Lordship takes the postal receipts at page 200. Postal registration slip, their document, Lordship, not mine.
Yes.
Kindly sees, Lordship, the first person named is the pro forma defendant. Kindly sees the weight, Lordship, 60 grams.
Yes.
Lordship kindly goes over to the other postal registration, that is one of the defendants. Also sees, Lordship, 60 grams. All of them, Lordship, show 60 grams, with the exception of, Lordship kindly turns over to page 201.
What is your allegation that this plaint has not been served?
Annexure has not served, and Muchipara OS, Lordship, has been served with all documents. Kindly sees 380.
How have you got this copy of the plaint?
Lordship, from the, I later on asked for it at the time of hearing. At the time of hearing of the 151 application, I moved my point that my written objection says no compliance. The learned trial court asked. Now an admission was made that requisites have also not been filed. The records.
Where is that? Where is that?
It has not been recorded. Kindly sees the impugned order. There is no recording. The learned trial court has not even made a passing mention of this vital fact, my lord. Kindly sees. In view of my submissions, kindly sees the impugned order. 19 है तो kindly sees what has been recorded.
Yes, but one thing, if you do not have any right with regard to flat number D, you cannot be aggrieved by this order.
But the police, lordship, with the utmost respect, now Muchipara Thana has been activated. Now they are coming and harassing me. My respectful question before my lord is, at the instance of a plaintiff, on a baseless allegation where 39(3)(a) not been on the strength of their document, if I may put this question to myself, can the police come and harass me? Which is exactly what they're doing.
Have you filed, but this application was allowed without giving you any copy? 151?
151, no, lordship. I was served a copy. I filed my written objection.
Where is the written objection?
Written objection, lordship, is
Page?
at, kindly gives me one moment. Kindly gives me one moment. Written objection will be page, lordship,
173 onwards, my lord.
And kindly sees, lordship, 174 and 175 are my specific governments. Kindly sees 174, paragraph 10.
No, paragraph 11.
Yes, lordship.
It is an admitted position that the defendants are not strangers. These defendants have been lawful tenants on the trust of which the plaintiff is a trustee. Incidentally, the performer, defendant number 4, is awaiting induction as trustee as heir of his father, who was the trustee. These defendants are looking after the said suit schedule property of the defendant number 4.
Yes, my lord.
From your case is that you are looking after that flat.
Yes, lordship. Admittedly, December 2025, because the pro forma respondent number 4 is admittedly in possession.
And how are you related with the pro forma defendant number 4?
I am a tenant, lordship, and his friend, all on affidavit.
So you want, you are awaiting induction as a...
Not me, lordship, the pro forma defendant number 4. That is the subject matter of a separate suit before this honorable court, between the plaintiff and the pro forma defendant number 4. Hmm, 153. Kindly also, my lord, 153 bar kore de. 153.
Where have you stated that you are the tenant in respect of flat number B?
Lordship, kindly gives me a moment.
In your written objection?
Lordship. That is in the plaintiff case also, lordship.
No, in your written objection.
Lordship, I have not specified which apartment, but page 175 kindly sees, lordship, admitted position that these defendants are not strangers. These defendants have been lawful tenants. And that is, lordship, the plaintiff case also, that I am the tenant.
It's one building consists of several blocks.
Several flats, lordship, on 2 wings of the building, I understand, segregated into alphabets. Plaintiff ek bar kar to page 21. Lordship, the plaintiff case also runs thus at page 25, where the plaintiff says that I am tenant.
Yes.
In respect of flat number B, block E on the ground floor. And the other defendants are my wife and son respectively. In light of my written objection, my lord, I draw my lord's kind attention to the impugned order.
Yes.
That is, lordship, at page 19. Kindly sees. My most respectful submission, my written objection has not been considered. The operative portion is at page 19. Kindly see what the learned trial court has recorded. Penultimate 2 paragraphs. on page 18.
Yes.
Kindly, may I read?
Page
Lordship?
18
Page 18, my lord.
of the
Of the application, I have annexed the impugned order separately for my lord's convenience.
yes.
May I place from there, lordship?
I'm reading from the certified
Yes,
copy.
may I place, lordship? Then on internal page 1 of the impugned order,
Yes.
the penultimate paragraph.
Yes.
Learned advocate on behalf of the defendant numbers 1 to 3 filed written objection against the application, categorically stated that the application is not maintainable in law and or in fact same barred by provisions. Kindly sees thereafter plaintiff has no cause of action for filing, false, frivolous, vexatious, speculative, harassive, malafide motive. Denied all material allegations.
Yes.
Most respectfully, my lord, the crux of my written objection, although this was what the oral arguments were based on, non-compliance of 39(3)(ab, and lordship, the fact that on what basis this police complaint was filed. Within a span of, I say 24 minutes, my learned friend corrects me, says less than 24 minutes. His allegation is I trespassed in the afternoon. He sends out a letter by post to the PS within 24 minutes of the alleged occurrence. Today, lordship, in law, most respectfully, this injunction order cannot survive because of non-compliance of the fighter.
I'm not in appeal against
No, I am not. I respectfully bow down to that.
So you take steps, you file your written objection.
Lordship, this order, police help has to be set aside is my respectful submission. There are no grounds. Kindly peruses the impugned order. What is the ground for police help? Kindly seize, my lord.
Yes.
My grounds today for challenge are, I bow down to my lord, not on the merits of 39(3)(ab. But be that as it may, my lord, the impugned order, most respectfully, does not take into account
Which page is the ad interim order?
Lordship,
168.
160 to 161, lordship. Parent order of ad interim, 22nd May 2026. Yes. Page 160. Right? 160, lordship, annexure C.
160 or 168? Yes.
My lord, it order dated 22nd May 2026, my lord.
Yes, 22nd May. I am at 22nd May. Issue notice. Restraining further. 168 and 169.
Lordship.
Are forcefully and further restraining from dealing with or encumbering, alienating, creating any third-party interest.
Yes.
Or inducting any other person in any person or changing the nature and character of the suit. So you cannot change the nature and character of the suit. You cannot. Yes, page 168. Yes. Yes.
My lord, kindly see page number 175. My lord, perhaps already seen.
Yes.
The admission, my lord. My lord, it's from 13, page number, line number 13, 175. It is a fact. It is a fact that the pro forma defendant number 4 had entrusted these defendants to look after the scheduled flat in his absence, as he frequently travels for business purposes. In pursuance of such entrustment, these defendants are in lawful possession of the keys of the said suit scheduled flat and entered the same on such apparent and ostensible authority to ensure its safety and general upkeep. It is also an admitted position that these defendants are not strangers to the plaintiff. These defendants have been lawful tenants under the trust of which the plaintiff is a trustee, and incidentally the pro forma defendant number 4 is awaiting induction as trustee as heir of his late father, who was a trustee during his lifetime. These defendants are looking after the said suit schedule flat of the pro forma defendant number 4 since December such and the said facts are well known to the plaintiff. Therefore, no question of illegal ingress or egress or any attempt on the part of these defendants to create or claim any right or title or interest over the scheduled flat, but the plaintiff by suppression the material facts such and such. Now, my lord, kindly see Why I am giving much stress on this? My lord, in middle portion, it is written that the defendants are looking for flight of the performer defendant number since December 2015. But before it, he has said that he has every information that the performer defendant number 4 is awaiting order from the court becoming a trustee. Now, if your lordship kindly take up the order of the Honorable High Court, it is appearing at page number 142. My lord, kindly see page number
Page number?
142 once.
Page number
142,
142.
my lord. My lord, the suit was filed by the father and uncle of the pro forma defendant number 4 for mismanagement of the trust, and various other allegations were there. Now, my lord, kindly see the appearance of the learned advocates on behalf of the plaintiff. My learned friend, who is now appearing for the tenant, was appearing on behalf of the father of the pro forma defendant number 4. My lord, kindly see. My lord Justice Mitra was leading her, and she was the advocate on record, and she knows everything about the suit. Now, my lord, what happens? While the pro forma defendant number 4, my lord, the suit is still pending. The pro forma defendant number 4 has filed an application for substitution with a prayer so that he may be inducted as trustee. We have said, we are the defendant in that suit. We have said that when they were leaving, the plaintiffs of that suit are leaving, they expressed their intention to retire. And as per the trust deed, we had to remove them from the trustees. And the substitution application was allowed for continuing the suit, but the pro forma defendant number 4 has not been allowed to be a trustee in the trust property. Trust. Now, he is taking the opportunity, selling the flats to some third persons. And these defendants, my lord, by hook or crook, are trying to grab that property. My lord, we find later, my lord, it is annexed here. My lord, kindly see page number 153, my lord. My lord, kindly once, my lord. Page number 153.
Who is in possession of that flat? Flat number
Pro forma
D?
defendant number 4, my lord.
Where have
Pro
you
forma
stated in
defendant.
the plaint? Where have you
My
stated
lord,
in the
kindly see
plaint?
page number 153, my lord. It has been annexed with the plaint, my lord. Page 153.
No, in the plaint, have you made any averment with regard to that? In the plaint, please show me from the plaint.
My lord, I have.
যেখানে বলছে যে কেন দরকার ওকে no averment in the plaint, my lord. The only paragraph pertaining to the role of the pro forma respondent is at page 28. Internal paragraph 23 of the plaint. Kindly sees what the plaintiff avers. No relief has been claimed against the defendant number 4.
Yes, which page you are saying that the defendant, pro forma defendant number
Page
4?
153, lordship.
My lord,
I was also
153, my
relying
lord.
on that.
My lord,
153 is what?
153, part of the plaint. It's a document annexed to the plaint, forming part of the plaint, lordship. Kindly sees addressed by the plaintiff.
All right, let him submit.
Yes.
Yes, page 153. Yes. Yes, sir.
pro forma
153.
defendant number 4 by a letter informed that there is already an order of injunction from the High Court. Suit is pending. So don't venture upon anything. And he was trying to sell it to some third persons, not the defendant number 1, 2, 3, but he was aware that you should not encourage this type of dealings with that flat. Thereafter, my lord, the letter was sent on 8th May 2026. He stopped. He stopped inviting outsider peoples to come and to take possession of the flat. Then on 19th of May, my lord, this defendant tried to break upon the flat. My lord, that time, pro forma defendant number 4 did not came forward.
Yes. Yes. Yes.
Now, my lord, from 2003, my lord, these defendant are tenants in the premises. My lord, will find from page number 60, that's a report of the receiver filed in 2010 in a appeal. My lord, will find from page number 60.
Receiver is in charge of this property.
No, my lord. That time there was a suit in civil court challenging the trusteeship, and thereafter the decree was went in appeal in division bench of this honorable court. Then a receiver was appointed to file a report. And my lord, in the report, my lord, at page number 64, my lord will find from page number 64, second paragraph. My lord, see on the western wing, and Shubhra Pal are joint tenants. The monthly rent is rupees such and such. The tenancy was taken in May 2003. From
Which
the
paragraph you are
erstwhile
reading?
occupier.
Which paragraph you are
My
reading?
lord, page number 60, page 64, second paragraph, my lord. Page 64, Roman 2, second paragraph.
What is 64?
My lord, that is a part of the report, my lord. Filed in 2010 before the division bench.
Yes.
Now, my lord,
But all these were not considered while passing the ad interim order of injunction.
No, my
These
lord,
were not
those are-
considered.
No, my lord.
These were not considered. Please restrict your submission with regard to the interim order and implementation. Please don't show other documents. Plain
my lord,
injunction
interim-
application, because these were not considered.
Yes, my lord. I just
show me-
wanted to show, my lord, I
Please
just
show me
wanted to,
that
my lord,
ad interim order of injunction was passed referring to this. Please show me.
just a minute, my lord. My lord, the penultimate paragraph of the order of ad interim injunction, my lord, 22nd May 2026, man.
Yes.
The part of the aforesaid trust estate situated premises number such and such contains several flats which are occupied by the trustees as well as tenants, and on 19th May 2026 at the late hours, the defendants opposite party number 1 to 3 being the tenants of flat number B, which has been referred in the receiver's report, my lord.
Yes.
Block E on the ground floor of the trust property were trying to break open the padlock of flat number D, Block E, situated on the first floor of the suit premises, and trying to enter into the aforesaid flat, and on being registered by the trustee, the defendant opposite party number 1 to 3 left the place but threatened the trustee that they will return with more people and forcibly encroach flat number D, Block E, situated on the first floor of premises number such and such. That exactly my case, my lord. That exactly my case.
Yes.
He has the dependents petitioners deposited the rent in the month of May 2026 to the trustee for his tenanted occupation, and here he is trying to substantiate that he has been permissibly occupying from a person who has not been the trustee, is of trying to take possession of the another flat, knowing fully well that the entire property, the owner of the entire property is the trust. And he has deposited the rent, my lord, for his tenancy.
For which flat?
For his tenancy, my lord, that flat number B on the ground floor.
He is a tenant, there is no dispute. He
my
is a
lord,
tenant, that is not dispute.
My lord, I am not telling you. That the trust is the owner, but he is taking possession from pro forma defendant who is not the owner.
Yes.
This is my simple case, my lord. He is the tenant for last 23 years. He knows who is the owner, who is the authority, who are issuing the rent receipts, and taking possession or taking forceful possession of a flat is occupied by another person. How can it be? And he is substantiating. And my lord, I'm sorry, I've already shown your lordship that when to 2019, the Honorable High Court has passed an order of injunction. My learned friend was representing the plaintiffs, who was the father of the pro forma defendant number 4 in the suit. That is already pending. That is also pending.
Yes.
Pro forma defendant number 4 is not coming forward now. We have filed, in the meantime, my lord, we have already filed separate appropriate application against the pro forma defendant number 4 in the pending suit. My lord, that will proceed, my lord, that will come in due course, my lord. Now, where is the scope, my lord? If your lordship by any means, my lord, stays the order or by any means vacate the order, my lord, they will again go and try to encroach upon the flat, my lord. And on the last occasion, my lord, they have filed an application for adjournment so that injunction order should not be heard.
Yes. Ashok. This Next. 501 fixed আছে একটা 4টের সময় টা। Yes. Yes.
Next, may I show the plaint on which Order 21, Rule 29 principles are being on which Order 21, Rule 29
Mr. Mittal, let your learned friend, he's the petitioner, let him make his submissions thereafter.
Yes, let him make his submissions.
Yes.
Or she'd asked me, that's why I was just.
No, I inquired from you to understand the scope of this civil division application. You have completed your other matter.
Yes, I know.
Yes.
Let's kindly come to operative part of the operative suit. Page number 20.
Page number? Running page number 3. Internal page, sorry. Internal page number 3 of the impute order. Yes. Yes.
I paid for a transfer from the 7th bench to 12th bench. The petitioner made a process just 2 or 3 lines. I am starting from this paragraph. So, if this quote, last paragraph, each of the opinion that it is necessary in order to ensure the proper distribution of the business to the suit or proceedings will be transferred to any other judge of the CBC. The petitioner of the instant case seeks transfer of the existing proceedings pending bench 7 of the CBC court on the ground that another title suit concerning the same property is pending with another bench of this court. That is bench 12. The execution proceedings which is connection with the deed passed by the Honorable Division. Moreover, the bench 7 has the decision for the execution of the deed. On the other hand, the present opposite party is not the party in the title suit. Moreover, in view of the Rule 101 of the Order 21 of the Code of Civil Procedure, all questions relating to right to the interest of the party arising with the party relating to the execution proceedings will be disposed of by the executive court and not by a separate suit. So, no case has been established by the petitioner to justify the transfer of the execution proceedings pending before the bench 7 to bench 12 of the CBC court. Thereafter, certain judgment has been referred for executive hearing. Kindly come to page number 44. What is the issue frame in the pending suit?
No, please show me the decree in the earlier suit from which execution is pending. Let me have an idea of that execution scope of that decree.
That order is not with me, but subsequently
Mr. Mittal, do you have a copy of that judgment?
Division bench decree I have. I gave to the review judgment.
Yes, the parent judgment.
And there is a Supreme Court from this.
Supreme Court is
dismissing this.
That is the liberty given all pending cases.
No. Let me see the have an idea of this. What is the suit for? So this is a decree for eviction of a licensee. Licensee eviction decree was passed. That is put into execution.
Yes. Now, I have challenged this order to the Honorable Supreme Court, but the pending all pending proceedings controls and reversal to be granted.
Pending proceedings.
Other matter is also pending.
Yes, that may continue. But this decree has not been interfered with. That has been dismissed.
During at the initial stage, I have filed an application order 711. That application was pending for dismiss for default. That is restored. I have filed an application because that is a
Order 711 of which suit?
that against which the decree is passed. Suit was this.
Nothing remains now after the decree is passed.
That is interesting, but one important point is this. Supreme Court in a judgment, Section 41 of the Precedents and Non-Course Court Act, like clearly interpreted, only leave a license equipment to small cost, not the citizen. That judgment has been somehow misinterpreted by the Honorable Division Bench.
I cannot interpret. I cannot interpret the decision of the division bench.
I have filed an application before that the pending CO, the pending CO, divisional application. The matter be placed before the appropriate bench for deciding the issue.
This CO.
That matter is pending in court number 9. Justice Kishore Basu. Whether the suit between the licensor and licensee maintainable before the civil court or small cause court. Because as per the Supreme Court decision, only small cause court the exclusive jurisdiction. In this matter, what happened? Paragraph 71. It is held the city civil court and small cause court has the concurrent jurisdiction for licensor and license. Paragraph 74 says, 71 says concurrent, 74 says small cause court has no jurisdiction, exclusive jurisdiction.
Paragraph 74 of what? This.
The big order, judgment. Paragraph 71 and 74.
First to review.
No, not the original judgment. 1912, 2025. Paragraph 71 and 72. Kindly see. Concurrent jurisdiction.
It held the city civil court had jurisdiction.
Section 74. Small cause court has no jurisdiction. Kindly see. First line. 74. Paragraph 74.
The initial suit was filed before which court?
City civil court. I have challenged the maintainability. Then the justice said and the stay. During stay, matter was dismissed and dismissed for default. And in the meantime, they proceeded expert and the suit was dismissed.
Against that, an appeal has been carried.
Again, the appeal has been carried by the plaintiff, and that pending since 2014 to 2025. During this period, the original landlord went application. The present duty holder is the substituted in 2025, and it is actually confirmed in December 2025. Suit was filed in 2020, immediately after auction sale. I have challenged the auction sale because the building itself is unauthorized, the building is not a development cost, the building can be public auction. When I raised the issue before the division in a review, that has not been answered, that has not been adjudicated. Only we are recording the demolition proceedings is passed and we are not inclined to because already is passed. That means the issue is already has to be decided. What the division is decided, whether a license or a license, and the degree should be passed or not. No right added interest has been decided. So the status has not been decided. Even in the review, that order before your lordships kindly see, there are 4 forums: rent controller, tribunal, NCLT, NCLAT held. You are a tenant, even that is admitted by the liquidator. Even in the review, there is a mistake. Admission is on the part of the liquidator and admittedly recorded.
I cannot sit in appeal over the division bench.
Yes, I am just narrating the fact in a brief manner. Why?
I cannot go on that.
Yes, I know. But why I am praying for transferring this case from 7th bench to 12th bench? The reason is this, and refusal this, I challenge this.
What is the scope of your suit? Let me see the scope of your suit now.
Kindly come to suit. Stage number starts from. I have amended the suit. Original suit position is.
Give me the amended plaint.
Not yet, but the original is also intact. Page number 22. Original.
So if it has not been amended, please give me the original plaint.
Original itself original. Only the underlined portion, if you let's overlook that.
So it's difficult. Please give me the non-underlined portions, pre-amended plaint. It's very difficult. Why have you annexed the portions which you are seeking to amend before amendment is carried out?
All right.
Yes. Oh, your suit is, according to you, that this construction is an illegal one.
So it cannot be put in public auction.
You proceed with the suit, succeed in
no,
the suit,
no.
get the building demolished.
No,
No difficulty on that.
I am not already.
Get the building demolished, get a
That is
decree
my
in the
point.
suit.
My point is this: when the corporation has already initiated demolition proceedings, so I have amended. So I am not required to pursue on that issue. So it's already initiated the appropriate proceeding. My point is this: it is a settlement, it is a division-based judgment. If the property is unauthorizedly constructed, that building cannot be public as well as no right that interest can be passed on. If that be so, degree was passed on the basis of the deed of conveyance, not examining the right title interest. And the same very issue when the pending suit is there, already original owners.
Building will be demolished. You succeed in the suit, no difficulty. I'm not saying that that demolition, let that proceed. There is no difficulty on that.
My point
but
is
the
this.
scope of that suit and this suit is entirely different.
No.
So this is entirely different.
That's true.
So if that's if the scope of the suit wherein decree has been passed from which an execution proceeding is pending and your suit is a different suit, why this should be clubbed? Why this should be placed before one court? Let it proceed. If that is demolished, that will be demolished.
What is the observation of the learned chief? Learned chief will observe that under Order 21 Rule 101, executing court examine the right title interest during the execution proceedings. The question is this: I am citing one judgment of.
No, you don't. I can clarify. If you don't want to raise any questions under Order 21 Rule 101, your separate suit is there. Proceed with that separate suit. You have a liberty under Order 21 Rule 101. The executing court gave you that liberty. If you do not want to avail of that, I record your submission that you are not going to avail of Order 21 Rule 101.
For a moment, executing court is also going for inquiry 101.
Executive court has protected your right. If you are not willing to avail of that, record says I can record your submission.
My only very limited point is this.
Thankfully, they have not come up.
No, I am just citing one judgment. Why it is stated.
Thankfully, they have not come up.
They are the judgment debtor. So what? So 101. What will they do? They are judgment debtor themselves. 101, Rule 99, 101. He's a judgment debtor himself. How can he take Rule 99?
That is the point because
Mr. Mitro, here it has been said he can apply. So that is against you. So that is what I am saying.
Yes.
They should have been agreed. They have not come up.
We should have come up in revision. Lordship is right. Lordship is right.
And that if he does not want to avail of that, I can record that.
I'll be saved.
You have given much better relief by the executing court. Thankfully, they have not challenged. Now you decide what to do.
But one point is this.
Sir, the scope is entirely different. What points you are taking, you succeed in your suit. That will remain, that will go on. You succeed in the suit, get a decree, let it be demolished. They will go. They take possession from you today. Tomorrow you get it demolished, they will also be evicted.
Sweet revenge he will have.
Yes, he will be having nothing.
That too, he has asked for demolition from 4th floor upwards. He's on the 2nd floor. So that's so 4th floor upwards, if it's demolition.
What actually happened? That is
Anyway, that's I'm not on there.
Whether the building should have been put in the public auction or not.
That's your suit. You proceed with that.
Now,
and here also you have been given liberty under Order 21 to 101.
If your lordships permit, both the two courts will continue for the same subject matter for.
I'm not saying I'm only on this execution. You are challenging this regarding transfer. I'm on that. I will not say anything.
Absolutely. So that if the matter.
I'm not going to make any further observation whether this should be transferred to another court or not. I'm only on that.
If it is transferred to the bench 12.
Not unnecessarily executing court. This is an execution. This court has the jurisdiction over that property. Why Why it will be transferred to any other court?
Because of the reason, if it
The scope are different. If you want to go into that, I have to make those scope is entirely different. Decree and why it should be clubbed.
my point is order one additional party.
Additional party?
Additional party in the matter. Pending suit.
In your suit, you have added
Yes,
him.
because after substitution, he is the necessary party. Now the order 21 to 29 application only on the ground, not order is uploaded. Today, is just rejected. On the ground, he is not a party in the pending. It is merely technical. Because the suit originally between the landlord and tenant and landlord. Both the two suits are.
No, scope is different. Scope is entirely different. Scope is entirely different. Scope is not the same. Maybe landlord and tenant have been incorporated two suits, implemented. That does not make two suits same. It's very difficult to digest. Scope you cannot make. Maybe plaintiff, landlord, defendant, tenant have been made parties in various suits. That does not make all suits scope same. That is very difficult to digest. That is why I wanted the judgment of the decree which has been put into execution. And the other issues which you are saying, division bench has misinterpreted, review, I cannot go into those.
That I am not making.
I cannot go into those. Yes, I cannot go into those. It is for you to take appropriate steps in accordance with law.
I am not on that.
So I cannot go into that. But apart from that, scope is different. This should not be tagged. Should not be brought before the same court.
My suggestion is for avoiding multiplicity of the proceedings, because on the same very
no multiplicity of proceedings. One, the proceedings has ended up to the decree, only execution. No multiplicity. What multiplicity?
Kindly seek this judgment. I am relying on judgment out of 20. Kindly consider.
Yes. On what point?
During pendency of the execution, the scope and ambit of the executing court, including the all relevant provisions, 101, 97, everything, elaborately discussed.
No. For what you are citing these? For what proposition?
That means the right title interest has to be decided by the executing
that
court.
Liberty has been given to you. Order 21, Rule 101. That liberty has been given to you. So see,
yes. That is by the chief judge. But my only point is,
Mr. Mitchell was aggrieved. He said, no, I am not aggrieved. He wants to go by that. What can be done? So that protection has been given. Executing court is conscious of this proposition.
It is not executing or chief judge. The order passed by the chief judge.
All right. So it has was conscious of that. Has made those observations. Order 21, Rule 101. Whether it's maintainable at the instance of a judgment debtor. There is one old decision of the Supreme Court.
No, that judgment is also there. That judgment is also covered. All the PPPs, all those.
1995. 1995, there is a judgment which says it can be any.
But not
any person interpretation is including the judgment debtor.
But the recent judgments are
any person has been defined to mean even the judgment.
Yes, that is the law.
That's the exact language used in 1995, maybe volume number 3 or 5.
But
volume.
Anyway, that's not the issue here. But recent
that's neither here nor there, because while on that side I argued before a division bench on this maintainability, but maintainability was not decided on merits. It was
for the judgment debtor you wanted to file. Lordship wanted to file.
Yes, Mr. Judgment debtor.
Yes, any person
judgment debtor and
debtor.
the division bench at the order 40 on stage, and the bench was heavily against me. Said no, not maintainable. But thereafter maintainability was not decided. But on merits, somehow it was done. That's a different thing altogether. So I'm aware of that judgment. So it deals with 1995. I think 1995.
This is 2025.
There is a
that one. Yes. There are three.
Was
I
it
think
considered in this judgment?
Yes, considered that.
Please show me that paragraph.
Yes, yes. That is a larger bench, I think.
No, no.
2025.
That
5, 6,
you
8.
say any person that has been
Including judgment data.
Yes, including. Where is that? Which judgment?
Yes, I have marked in the. I think I have in the first page. I have.
Please. That's an interesting judgment.
Page 18 and 24.
That's an interesting judgment.
Including the judgment data.
Any person was defined by the Supreme Court, including
any person,
including judgment data.
Any person, even including the judgment data.
Where, which paragraph? Which paragraph?
Which is page number 18, para 6, subpara 6.
Page number 18.
18, 1-8. Subpara 6, bold portion. Subpara 6, bold portion.
Paragraph
43, subpara 6.
So this is a quotation of which judgment? From which judgment?
Brahmadev Chaudhary.
Yes. 1997 3 SCC.
It's nice, but that is clearly indicated. The judgment data has a right to raise an issue.
A reading of Order 21 envisages that any person, even including the judgment data, irrespective whether he claims derivative title or not.
I know it, but I am covered. But my point is this: the two courts will proceed on the same issue.
You have been, you are covered. You have been given benefit. So.
I am not.
Ashwin.
more particularly put to public auction, white e-auction share service provider such and such, when there was is or no original sanction plan, as such, without having any sanction plan, title cannot be passed on to the buyer. Whether entire G+7 story building, that is, I am not pressing this. Kindly come to issue number 8. If the said e-auction process of lot A was continued to draw in such event, all
not yet a party.
I have made application for the.
Let it be done. When he will be made a party.
Should be made so that other it will be later on it will be impediment. That here application is
At
there.
this stage, he is not a party. At this stage, he is not a party.
But the order is there 13th October for passing order on that application. Next day.
Let it be passed. I have not said anything with regard to that.
Otherwise, it will be your lordship's order will be impediment later on. This that observation was that. So there should be any application order 21 rule 29. That would be problem. That would
I have not said anything.
Rule 29.
I have not said anything.
That will be kept open.
No. I have not said anything with regard to order 21 rule 29.
I can file again, or I can file challenge the order and reject an order.
Yes.
That is be kept open. That is be kept open. Otherwise, it will be kindly.
Please.
No. I cannot understand what you are submitting. What you have filed an application for addition of party.
That is for passing order on next.
Yes, I have not said anything with regard to that. I have not yet said that they are not a party.
But that issue directly affect them. If your lordship is entirely different, that they will take a plea. That suit is different, so I will not be added their party. Because that is no related.
I have not said that they have not been added a party. I have not given that.
Not a party is a matter of record. Your lordship said so.
They will show your lordship's order to the trial court.
If I was a party, then your order 1 rule 10 won't lie. You're not a party.
Have I said that they are not yet party in your suit? Have I said anywhere?
What is my
Please say I'm already a party.
Have I said it, Mr. Mitchell? Yes. Yes. I have not said anywhere that they are not yet parties. Since you are saying that these are the issues, that is why I have said that they are
entirely different. Entirely different means these
That's my last finding.
These issues come directly affecting him. All purchasers. I have already filed an application for paper publication. All the buyers will be at a party. Not only that, otherwise it will be affected. Yes.
After going through, after going through Thank you.